Good morning. Thank you for joining us. Today is March 28th, 2019, and we present for the first day of two-day Acupuncture Board meeting. The meeting is taking place in the Department of Consumer Affairs, Hearing Room, Suite 186, 1747 North Market Boulevard, Sacramento, California, 95834. This meeting will be webcast. The time is 9:40. Christine, please take a roll call to establish a quorum.
Dr. Mateki?
Present?
Chan is absent. Semino?
Present.
Harabedian?
Here.
Kim?
Here.
Lee?
Here.
And Osorio is absent. We do have quorum.
Thank you, Christine. Please let us welcome our new board members. I would like to give a brief introduction. Detailed information is available on the Acupuncture Board website. Bradley Semino, governor appointee and a licensed member. He has owned the Proactive Acupuncture Center for Asian Healing Arts since 2006 and was a professor at the University of East-West Medicine from 2010 to 2012. Francisco Kim, governor appointee and a licensed member. He has been clinical director and acupuncturist at the Hillstone Medical Clinic and an adjunct clinical instructor at the Touro University College of Osteopathic Medicine since 2014. Shudong Lee, appointed to the board as a public member by Assembly Speaker Anthony Rendon. He has served as president of the USA Tai Chi Foundation and as a board member of the United States of America Wushu Kung Fu Federation. He is the 20th generation descendant of Chen-style Tai Chi Chuan and is a doctor of physical education. And I want us to give applause for our new member, Shudong Lee and Semino, Bradley Semino and Francisco Kim. Thank you. And thank you for your willingness to serve on the board. Before we move on to the next item on the agenda, I would like to announce one of our former board members, Mr. Francisco Xie, passed away 2 days ago. We appreciate his dedication and contribution to the board and the people of the state of California. I would like to ask for a moment of silence to honor this great individual. Thank you. Now we would like to move some Friday's agenda items and regulatory work to accommodate board members' availabilities. If you have the agenda in your hands, please take a look at. We're planning to move Friday agenda item 5, Executive Officers Report, to today after item 8. Board member committee member assignment. And we will move Friday item 7, regulation update, to today after Executive Officers Report. And also we will move Friday agenda item 9, education report, to today after regulation update. And we will move today's closing session agenda, items 12 and 13, executive officer evaluation, to Friday after agenda item 11. So let's move to agenda item number 3. The board will now hear public comment for items not on the agenda. Please limit your comment to 2 minutes. Seeing no more public comments, the board will move on to the agenda item number 4. Ben, can you go through the number 4, please? Thank you.
Thank you, Dr. Matecki. I would like to invite Sean O'Connor, the board's partner with the Office of Information and Services, to provide us an update on the board's business modernization plan that we have been working on together for the last year, a little over. Welcome, Sean.
Thank you. Thank you, Madam President, board members, Acupuncture Board leadership and staff. My name is Sean O'Connor, and I am with the Office of Information Services. And my role in guiding the board and their staff through the Business Modernization Initiative is to act as the project director and provide a level of IT consultation and guidance to make sure we select a IT system that works well and complements the Business Modernization Initiative that the board is currently undergoing. Now, I understand, based on the earlier content of the meeting, that we have some new members, so I'd like to take this opportunity to go through some background on the Business Modernization Initiative, provide some updates on how much progress we have made with the Acupuncture Board staff and leadership to this point, and orient you to what will be coming over the next 6 months to a year as we proceed through this process. And then at the end, I'm happy to answer any questions you all may have as to what's ahead for the board or where we're at in our current status. The Business Modernization Initiative is being undertaken individually by 17 different boards and bureaus here at DCA. Acupuncture Board is one of them. And the Business Modernization Initiative is an effort that is a business-driven pursuit to take a look at our existing processes and see, in light of business process reengineering or available technologies to us, how we can modernize the way that the board does business. The process through which the Acupuncture Board and the other 16 boards are going through is they are working with the solid organizational change management unit here in DCA to completely map all of the as-is business processes that the board currently has. Everything licensing related, enforcement related, going through and mapping the as-is processes. Then working with the staff on areas where they want to improve to map what we're calling the 2B processes. So this is the processes where if we were to introduce technologies, introduce process changes, how could we make the processes more efficient or more responsive to our constituents? After that, the board will go through the California Department of Technology's project approval lifecycle. This is a structured approach to planning a project that all major project initiatives in the state go through. It's not unique to Department of Consumer Affairs. It's not unique to any of our boards. It is a process that has been used many times successfully over the last, I believe, 3 to 5 years is when the project approval lifecycle started. Some of the hallmarks of it are that we go through a thorough documentation of all the functional requirements and business needs of the board, go through exhaustive market research, and then baseline a project schedule and a cost after we've received input from all of our control agencies, as well as we've received responses to solicitations if we are going out to the vendor community to complete any portion of work. That helps us to create a realistic baseline and to prevent us from setting ourselves up and setting arbitrary milestones and dates out there early in the process that we will be criticized for later. So it just allows us for the collection of more information to make a more informed milestones and costing decisions moving forward. Acupuncture Board to date has already completed several of the early stages of this effort, inclusive of all of the business process mapping activities that I mentioned, the functional requirements composition, as well as they've completed stage 1 of the project approval lifecycle with the California Department of Technology. So we've received approvals on those. We also have, right now, with the California Department of Technology, our second stage of the four-stage PAL process is with them for final approval. I'm optimistic we're going to receive that in the next several weeks, and then we will move on through the process. I would like to say that while IT plays a role in this, and I regularly interact with Ben as well as the staff at Acupuncture Board to guide them, this is a business-driven process. We want the business to be the ones who decide what areas of their system they want to modernize based on the organizational readiness, the fiscal situation of the program, as well as what their goals are based on their regulatory profession. So we've been working very successfully with Ben and the staff to achieve those goals, and I think that positive momentum will continue forward as the buy-in from the executive officer and the staff it's just been awesome through this process, to be candid, as we've gone through it. So moving forward, upon completion of the approval of the California Department of Technology's project approval lifecycle stage 2 document, we will then begin working with the California Department of Technology on any potential vendor solicitations that we have going out there, making sure that we have contractual protections in there that protect the state, as well as working with them on baselining our project scope, schedule, and cost. And that will wrap up stage 3 and 4, and upon conclusion of that, we will be in project implementation mode. So we fully expect to begin the project sometime in the next fiscal year, in the 1920 fiscal year. So in upcoming board meetings, these sorts of updates may very well be about the fact that the project has started or has a start date looming around the corner. That concludes my update. I'm happy to answer any questions that you may have.
Thank you. Any question from the board members? Thank you, Ben.
Thank you, Sean.
Yep. Thank you,
We
Madam
really
President.
appreciate the partnership with OIS. Thank you.
Appreciate it. Thank you, Ben.
So let's move to
Want to do public comment?
public comment. No? Okay. Now let's move on to agenda item 5.
Thank you. I'd like to invite Patrick Lee, Deputy Director of Board and Bureau Services, to provide us an update from the department. Good morning, Patrick.
Good morning.
Morning.
President Matecki, Executive Officer Budea, members of the board. It is good to see you all again in beautiful Sacramento, and thank you so much for providing an opportunity for the department to provide an update to your board. For the purposes of the minutes and for the record, my name is Patrick Clay. I'm the Assistant Deputy Director for Board and Bureau Services at the Department of Consumer Affairs. And since this is your first meeting of the year, I thought I'd start this update by sharing an update and highlights from 2018 for our office and share with you a few figures and numbers. This past year, in 2018, we convened 9 licensing and enforcement work groups, which are work group sessions that convene staff from across all DCA boards and bureaus to share best practices in the areas of licensing and enforcement. We also hosted 3 substance abuse coordination committee meetings, and I'll talk about them a little more later, which examine drug testing frequency standards for licensees who are substance abusers. We also held 4 directors' quarterly meetings, which were opportunities for executive officers to connect directly with the DCA leadership team. And thank you so much, Executive Officer Budea, for participating. And finally, we hosted 2 directors' leadership teleconference calls, which are opportunities for board presidents and vice presidents to interact directly with DCA Director Dean Graffillo. So we hope that these activities promoted open dialogue and collaboration in our shared mission of protecting California consumers. And in fact, we're always looking for feedback. So if you have any suggestions about what you would like to see for 2019, please absolutely feel free to give us some feedback. So since I'm on the topic of discussing 2018 in review, I also want to let you know that the DCA 2018 annual report is now available online. The report contains a much more comprehensive account of all the activities and achievements of all the 37 DCA entities that make up the DCA family. So if you have a moment, whether you're a board members or a member of the public, I invite you to check out the annual report on our website at www.dca.ca.gov. My next update is regarding the transition to a new administration. And as you know, on January 7th, marked a historic new era for our state as California sworn in Governor Gavin Newsom as the 40th governor of the great state of California. We at DCA are honored and excited to be part of this new team. Our department is looking forward to doing all that we can to support and further the governor's vision. The department has met with the transition team, and many new and some familiar faces have already been appointed to new positions within the governor's office. As for current gubernatorial appointees, the message is that there is nothing that you need to do at this time other than continuing the great service and work that you have been doing. We intend to maintain close communication with the new team that the governor's office has put together, and we will be in touch with them regarding any appointment vacancies and pending reappointments in the near future regarding all of the DCA boards and bureaus. Related to the new administration, my next update is regarding the governor's 2019-2020 budget. And on January 10, as you know, the governor released his proposed budget outlining his fiscal priorities for the state of California. The new budget is based on the driving idea of a California for all. It proposes to pay down debts and pension obligations, continues to build up robust budget reserves while making significant investments in housing, child care, health care, preschool, and higher education. It also proposes some significant changes in the way that the state would purchase prescription drugs. On the day that the budget was released, we held a teleconference call with all the board leadership and executive officers to discuss the governor's proposed 2019-2020 budget and review proposals within the budget specific to the department. Our fiscal operations team should have followed up with every single DCA board to provide additional details about how the budget impacts your specific program. And I believe that the budget and how it impacts the department will be a full agenda item during this board meeting. My next update is regarding Assembly Bill 2138, which is also on your agenda, I believe, which is, as you recall, is the legislation that limits a board's ability to deny a license based on past criminal conviction. Because AB 2138 impacts nearly all of the DCA boards and bureaus, the department has taken steps to support our programs to achieve a successful implementation, which, as you recall, has an implementation deadline of July 2020. DCA provided programs with a draft timeline to stay on track, as well with sample model regulations that board can implement via regulations if they wish to do so. It is important to note that in order to stay on track, action will be required by all of our programs at the latest May of 2019. And to that end, the department has been working closely with all of the boards, again, to create these model regulations and create uniformity. Where feasible, the department will also take the lead on collecting data for the reporting requirements that are spelled out in the legislation. My next update is regarding the Substance Abuse Coordination Committee, which I mentioned earlier. So the committee, which is made up of all the healthcare boards, are supposed to come up with standards regarding drug testing for licensees who are substance abusers. So I wanted to report back that the committee met 3 times in 2018, and there were 2 changes that were made regarding to Uniform Standard number 4, which guides the protocols around drug testing. The first change added language which allows healthcare boards to approve alternative drug testing locations and alternative drug frequencies for a licensee going on vacation or taking a leave of absence. This change was added to ensure that the board can still perform drug testing for a licensee traveling abroad while considering the varying types and availability of testing laboratories around the world. And the second change is a policy addition that allows a board to lower the drug testing frequency to not less than 24 times per year if the licensee receives a minimum of 50% direct supervision per day in the workplace. And this change was added to reduce the testing cost for licensees who are already under supervised monitoring at their place of employment. This change would be added to the list of exceptions that already exist under Uniform Standard number 4. That committee also determined that several other standards need review. So to that end, DCA will be conducting additional meetings throughout this year to examine and potentially change other standards beyond drug testing protocols. And again, although these changes were made, it is to the purview of every individual board to decide to implement them via regulations or through their disciplinary guidelines. And my final update, a bit more tame, is more administrative. Is some friendly reminders. The first one is regarding board member orientation training, or BMOT. And as you know, board members are required to complete this training within 1 year of appointment or reappointment to a board. It's a one-day training in the most beautiful city in the world, Sacramento, which details the important functions and responsibilities of board members. The second reminder is to file your Statement of Economic Interest, also known as Form 700. It is required by the Fair Political Practice Commission to report potential conflict of interest. The filing deadline is April 2nd, so very soon next week, and can be easily conducted online. You are required to file even if you do not have any reportable interest. I have done mine yesterday, so hopefully you can join me in being compliant with the law. My final note is that 2019 is a mandatory sexual harassment prevention training year for the Department of Consumer Affairs. This means that all employees and board members are required to complete this training this year, even if it was completed last year. This training is online, interactive, and can be completed at your convenience. Obviously, here at the department, we want to make sure that we can create a safe workplace environment for all of our employees and partners. So, of course, if you have any questions about this or any other required trainings, feel free to contact your executive officer or myself or any members of the Board and Bureau Services team who are happy to assist. So that concludes my update. And as a point of personal privilege, I want to express my sincere thanks to the executive officer, to the board members for this great partnership that we have. And thank you so much for all the work that you do to protect California patients and California consumers. And I'm open to take any questions that the board may have.
Thank you, Patrick. Any questions from the board members? No? Thanks a lot.
Thank you.
Thank you. Yeah. Public comments? No? Okay. Now let's move on to agenda item 6, please.
Thank you. Agenda item 6, we invited our Department of Justice Liaison, John Gatchett, to come and present before the board to give a bit more information on the Administrative Procedure Act and affecting the administrative adjudication process.
Good morning, everyone.
Good
Let's see if
morning.
I'm being picked up here
Morning.
as I organize.
I just want to point out that the board members have been provided with a handout for this presentation. They weren't included in the online materials, but copies are available for the public here, and they will be posted online after the meeting.
Thank you, Sala.
Thank you.
Sorry, we're having a little, I gotta get this PowerPoint up on the screen behind me here.
It is,
Do we get locked out?
there we go. I wonder if,
There we are, okay. All right, so my name is John Gatchett. I'm a Deputy Attorney General in the Health Quality Enforcement section. I'm one of 61 deputies in that section. We have 9 clients that are boards and then 1 program, Acupuncture being one of our clients. I've been the liaison to the Acupuncture Board for approximately 3 years now. So I've been working with the executive officer as a consult, and so one of the things that we wanted to do was offer our services. We have a number of new board members, about where the Attorney General's role fits in this, in your enforcement program and the procedures that you carry out. So the Licensing Act that the Acupuncture Act starts at is 4925, and then the sequences forward from there. And we've talked about it, actually, DCA finished up in their initial part of their presentation that the highest protection of the public is the highest goal of the board. And so where the Attorney General's office helps the board is in the enforcement program. The things that we don't do, these are the things that your legal counsel is your advisor on. And these are rulemaking, general administration of the board, licensure requirements, credentialing, continuing education requirements, probation monitoring, funding, fee schedules. Those are not areas the Attorney General's office helps. Those are internal areas the board has through their executive staff. They receive counsel from legal counsel through DCA's office. Ms. Bojack is your representative. Those are areas that we have very little in day-to-day function. Where we do is in enforcement. And so the Attorney General's office is a constitutional office elected. Current Attorney General is Javier Becerra. And so our office works under him, and then we act as your counsel in enforcement matters. And so when I take an acupuncture case, or whenever you take an acupuncture case, our client is actually Ben. So Ben is the complainant who brings forth allegations on behalf of the board in a disciplinary process. We draft an accusation. We provide it to the board in the sense of Ben. Ben, through his staff, makes changes, edits, and then files that accusation. And it's our job at the AGO to carry that accusation forward and to prove those allegations up. We also do probation violation hearings. It's a very similar process to the accusation. We get a referral from the office. We draft a pleading. It's called a petition to revoke probation. And then we provide it to Ben. Ben signs it and we file it. He, once again, is the client. We do statement of issues. So what happens if the board has a licensing situation where someone applies for licensure and the board wants to deny that license? Once again, that's Ben making that determination. I'm going to probably deny this license, and he'll cite his reasons. That's a transmittal to our office. We draft a pleading, which is called a statement of issues, and then we file it, with Ben being the client. And so those are contested hearings. And so those go forward. They're set under the Administrative Procedures Act, and we'll talk about that a little bit later in terms of the Office of Administrative Hearings. But that's where our role is. Our role is the enforcement arm under Ben to represent him in enforcement proceedings. And then the bottom one here is a little different, appearing at petitions for reinstatement of licensure or petitions for early termination of probation. You will have situations where licensees come and they ask for early termination of their probation that they're placed on. So let's say they're placed on probation for 5 years, and after 2 years they ask for early termination of that probation. Our office will appear, but we're actually not appearing on behalf of Ben or the board. We're actually appearing on behalf of the public, and that's under Government Code 11522. So that's a little different proceeding, but that's another area that we help in enforcement. Standards of care are a little different for administrative proceedings, and they can change depending on what we're actually talking about. So for example, a statement of issues has a different standard of care than an administrative proceeding where we're actually doing an accusation against a licensee. The reason for that is a licensee has a property right, and so to take their interest in their license, you have to prove the allegations by clear and convincing evidence, which is a higher burden of proof than maybe a civil preponderance standard. But in a statement of issues case, the licensee does not have a license. They're applying, and so they have to, when the board denies that license, they have to prove by preponderance the evidence that they should be entitled to the license. So the burdens of proof change depending on the action that's being taken against. And so up here I've got different types of interests or standards of proof. Beyond a reasonable doubt is the criminal standard that everybody hears, if you've ever watched Law and Order. And then civil, more likely than not, is the standard of proof. Those are different than what we deal with, which is clear and convincing evidence. Okay, so some of the areas and grounds for action, and this is not an exhaustive list, this is more just a thumbnail, but the types of things that you as board members will be reviewing in terms of decisions that you receive, proposed decisions from from the administrative law judges. will be allegations surrounding things like this: fraudulent acts, record-keeping issues, negligence or gross negligence or incompetence, areas where standard of care has not been met. There's a number of statutes in the acupuncture statute regarding bloodborne illnesses, proper needle protocols, and those are the types of things you may be looking at. Conviction of crimes, if they're substantially related to the practice of acupuncture. And so those are areas that the types of cases that we see that we deal with. And then we also have reporting requirements. And then finally, at the very bottom is sexual abuse and misconduct. And unfortunately, that does occur. And those obviously are some of the most serious cases that we have on behalf of your board when we're doing enforcement. Okay, so let's talk a little bit about application for licensure. And this is the statement of issues I was talking about earlier. When a licensee applies, they provide a license application. The board has three things that they can do generally. They can issue a license. They can issue a license subject to terms. And they can deny a license. One of the things you'll be voting on, I believe either today or tomorrow, I think it's today, is 2138, which is going to change this area of the law significantly for boards. It's going to limit boards on the types of convictions that they can use in denying licensure, and also change how boards use underlying conduct from those convictions in denying licensure. And so those are where those regulations come in. And it is going to change significantly how boards operated, how this board operated, how other boards operated. And so that's why it's so important to get those regulations done as well as they can for the board's purposes, for the enforcement purposes, and then done obviously as the law requires by July 1st, 2020. But that's the area that's going to change, and Business Professions Code 480 and those sections are going to change based on those changes in the law, and that's where your regulations will guide how you're reviewing that conduct. Okay. Now, this is different. This is more the accusation situation. So let's say you do have a licensee where the board has brought disciplinary charges against a licensee. What are the things a board can do? Well, a board, when you receive a proposed decision, or when Ben enters into a stipulation with a licensee on a case where there's been a settlement, and that happens in most of our cases when we enter settlements, Ben will, in a settlement situation, in a context, will make an agreement with the other side, the licensee, through our office, and usually their counsel or the licensee directly if he's representing himself. And Ben will come up with a settlement, and then that settlement will come before the board. And you will determine whether that settlement meets the board's disciplinary guidelines and fits with what the board feels is an appropriate disciplinary penalty. That's one situation you're going to review cases. The other way you're going to review cases is if it goes to an administrative hearing and an administrative law judge who's heard the evidence and then applies the facts, the law to the facts as he's heard it, makes a proposed decision. And that proposed decision usually will include a proposed penalty, and the board, once again, will review that proposed penalty and decide if that's in line with the disciplinary guidelines and as the board wants to see fit. And you receive help through your counsel explaining that and providing the options that you have, Ms. Bojack. The board has a number of general ways that it can deal with a licensee after discipline has been found in an enforcement context. You can issue a public reproval. That obviously is the lowest form of discipline. You could do a non-disciplinary situation, which is issue a citation. That does occur. You can revoke and stay a revocation and impose probation conditions. And those are set forth in the disciplinary guidelines. They can include a suspension period. And those terms can be modified and molded to what the licensee has done. So in a substance abusing situation, obviously there would be alcohol testing. That's a common term that's imposed. There's probably going to be a probation monitor imposed so that they can verify that that substance abusing licensee is not impaired at work. Those are the concerns that we have, and those are the concerns that you should have when you're looking at a probationer. And obviously every probation is different, every disciplinary case is different, and so there'll be reasons for imposing those terms. They need to be related to the actual conduct that occurred. You cannot pick terms that are not related to the conduct, or they'll be struck down. And that happens when someone files an administrative writ. They can strike a penalty down if it's capricious and arbitrary and not related to the underlying conduct. You can accept a license surrender. That's a common thing that also occurs. When cases are very serious, or when licensees have decided that the conduct is such and they don't want to be on probation, or where the board has decided that the board does not want to extend probation, because we're going back to that public protection statute, which is at the core of your board and at the core of all the other healthcare boards, the board can accept a license surrender, where a licensee does surrender their license. And finally, the board can revoke a license. So surrender occurs before a hearing. Revoking occurs after a hearing. And so maybe the evidence has come out such that the board is in a position where it's going to move to revoke a license, which is the highest form of discipline this board can impose on a licensee. All right. I think, did I go backwards? No, I did that. Okay, so this is the kinds of different cases that we have. We've talked about this previously, so I'm going to move forward from this. One of the things that this board has dealt with in the past is BNP 119, so allowing licensee to be used in a crime, or the license to be used in a crime. What the board has dealt with is sometimes prostitution around different acupuncture clinics and massage clinics, and that's something the board has been very vigilant about trying to stop that sort of conduct and working to stop that sort of conduct. And that's something that is maybe more particularized to your board than it is to some of our other clients, but that is one I want to point out. Okay, so substantial relationship, what does this mean? Well, this means that when you have a crime that's been convicted by a licensee, and this is something that discipline is brought on, so for example, a financial crime or maybe an abuse-related crime, in order to impose discipline as on the licensee, that crime needs to have a nexus of substantial relationship. The board has some guidance and guidelines in terms of defining what substantial relationship is, but it's also set forth in case law. Griffiths is that case. I would point out here that one of the things about enforcement is sometimes we'll hear, well, nobody was harmed. Nobody was harmed, nobody had any injury, nobody died. I would point out that in an enforcement proceeding, that is actually not what the board's concerned about. While that is a part that we look at in any case, and it's an important consideration, obviously, for patients, the case law, and this is kind of a legal view of this, is less concerned with whether there was harm to a patient and whether or not harm could occur in the future. And so harm or causation is not something that we really use in administrative proceedings, and that's different than in a civil proceeding. In a civil proceeding, to prove a tort, you have to prove that someone was harmed. So while you can be negligent, if no harm occurred to the plaintiff, there's no damages, and therefore there's nothing to actually have a civil suit on. In an administrative proceeding, harm to a patient is not actually relevant to whether or not there can be a deviation from the standard of care. It's whether or not the practitioner, the licensee, met the standard of care when they provided care to the patient, whether or not the patient was harmed. And so Griffiths, part of Griffiths is setting forth that, and that's a tenet that all of our boards follow, that really harm is not as relevant as whether or not when the licensee acted, they were meeting the standard of care. Couple cases here that make our situations a little different. Alvarez versus Sanchez, privilege against self-incrimination, the Fifth Amendment, you hear that a lot. In criminal proceedings, a defendant does not have to testify in a case. They can choose not to, and that can't be commented in that proceeding. Administrative proceedings are civil in nature. While they do carry some criminal or quasi-criminal evidence standards and procedure, they are civil in nature, and so in an administrative licensing proceeding, a person does not have a right to remain silent. The board will be able to call them, and we on behalf of Ben do call licensees and applicants to the stand and ask them questions. And if they choose not to answer those questions, that in itself can actually be a basis against the licensee for not being truthful with the board and actually speaking during a hearing. It can be something that can be commented on in imposing discipline. So that's a little different than a criminal proceeding. Plea of no contest will be treated as a guilty plea, so for licensing procedures. So that means that if someone pleads no contest, which is common in criminal court, I would say that's the vast majority of pleas, that in itself will still be treated as a guilty plea for licensing proceedings. Okay, we're now about 15 minutes in, and so I promised I'd be done in 30 minutes, so I'm well ahead here on schedule, so that's good. Watson, and then there's a case actually, Nursing Board versus Sulla, which is a 2012 case and a single DUI impacting a nursing license. I bring this up. Enforcement sometimes will involve criminal convictions that occur outside the practice of acupuncture, but we're going to be imposing terms on someone. And one of the things that we see is substance abusing licensees. DUI convictions, and what a DUI conviction, or 2 or 3, where that can come in a licensing situation. Often we hear, well, I wasn't drinking and driving on my way to work, and I wasn't drinking and driving at work, so why does it matter that I was drinking and driving on a Friday or a Saturday or a Sunday? And this will be fact specific. It will depend on the facts of the DUI, but boards, your board included, and many of our other clients, like the medical board, do impose discipline for convictions that are not occurring necessarily at work, for example, DUIs, where the facts tend to indicate that someone has an alcohol problem that is serious, and that is driving and causing an accident or driving with a very high blood alcohol content. The board will bring an enforcement action against that licensee, and the theory, or why the board can do that, is set forth in Watson, and that it's reasonable to understand that if you are drinking and causing problems in your personal life such that you're so impaired to be dangerous to yourself or the public, that we can take action, the board can take action in an enforcement context in order to prevent harm. And that goes back to Griffiths, Watson taking it forward regarding DUI and specifically, and then SOLA as well. And yes, a single DUI can lead to discipline. And that is something that's part of our enforcement. And the reason why is we hold licensees to a higher standard, and once again, it goes back to public protection. We can't have licensees with alcohol or drug problems that may or may be, they think in their mind, are kept in their personal life. The board cannot just trust that someone with an addiction problem can keep that in their personal life. And so the board will impose discipline, and the board will go through the process. And that may be rehabilitation for that licensee. That may be going through a diversion program or a probation program in order to get the treatment that they need and make sure that they're safe for the public. And that's really the overall writing thing here. The board is not here to punish licensees. That is not what the board does. None of discipline is not punishment. Criminal justice is punishment. Discipline is protection of the public and rehabilitation. Protection of the public remains paramount, rehabilitation second, but that's what the board's actually trying to do with its enforcement procedures. Okay, standards of care. So incompetence, gross negligence, repeated negligent acts. This is something that often even lawyers have a hard time with, judges have a hard time. What is the line between a negligence, gross negligence, and incompetence? And where this comes from is in an enforcement process, we use experts. Experts are hired by the board, so these will be licensed acupuncturists who are professional in their field, who have made themselves available to the board to review cases. We rely on them to review the conduct in any case, make a determination what the standard of care is, the applicable standard of care, and how that practitioner should have acted in a similar circumstance, and what basically the minimum level of standard of care is for whatever the procedure is that's being carried out, because lawyers are not practitioners. We have to have a witness provide that expert testimony, and then that expert testimony will determine where the deviation is on the standard of care. So what's the difference between these three things? Well, just because I said that lawyers don't understand the standard of care, judges do try to define what those differences are, and so that's actually in case law. Gross negligence is the want of even scant care. It is more than negligence. There are significant differences between simple negligence and gross negligence. Simple negligence you should think of is usually a minimal deviation standard of care, something small, a lesser deviation standard. I like to think of it as just simple negligence. Gross negligence is something much more. It's where you actually are avoiding the facts in front of you and you're not actually exercising any sort of care. So it's the want of even scant care. You're beyond a wanton and willful disregard is one way to say it, to what the standard of care requires, and that's gross negligence. So gross negligence is a higher standard or a higher deviation, more extreme deviation than simple negligence. Incompetence, we see that. Incompetence is actually probably one of the hardest things to actually prove, and I would say here's why. Incompetence is the idea that you have no ability, qualification, or function to actually perform a duty. So if you've been trained and you have education, which your licensees do, they've been trained, they've got a certificate, and then they don't do something, it's hard to say they're incompetent because they've been trained, they know how to actually exercise a standard of care, and they should be able to carry forth that standard of care. What happens when they don't do something, which you would expect them to do, is really gross negligence. It's that they have knowledge, that they know how to do it, but they're just choosing not to. So that's really gross negligence. Incompetence, and so example, I would go back, the medical board, where incompetence will sometimes crop itself up is, let's say you have a general practitioner of medicine, and they're just a GP, they're doing management, and then a surgeon, they decide to start doing surgery. So let's say a GP started to do gallbladder surgery in their office. That's incompetence, right? They didn't do a surgery residency, they didn't do a surgery fellowship, they really shouldn't be doing that type of procedure in their office. You'd really want to know, did they have the training experience to do that? And so that's where you would see that in acupuncture, it becomes hard because a licensee has training experience. If they're choosing not to use that with a certain Eastern medicine technique, that's really gross negligence. Now, if they were using a technique that maybe is not part of your practice standard. So for example, I know we had a case where a licensee surrendered their license, was using wooden thorns to do needling of the eyes. And that is, in my mind, incompetence, because that's not part of your standard practice. It's not part of your needle protocols. You're not, that violates all the single-use needles. Using a wooden thorn does not, in California, does not fit with your standard of practice. So to me, that would be the absence of qualification, ability, or fitness to perform, because you're using something that's completely outside the realm of acupuncture. So that would be an example. Okay, so this is just a quick example of how this all works. The board receives a complaint, triggers an investigation. Records will be reviewed. They may be subpoenaed. My office helps with that process to subpoena records. Licensees and witnesses will be interviewed. The evidence obtained will be provided to an expert, which we talked about. They'll review the standard of care, and then they'll render an opinion as to whether the licensee violated the standard of care. Burden of proof, we've talked a little bit about this already. It really just depends on the case. And so that's where we help Ben go through this. Your legal counsel will know the burden of proof for all the cases that you have because it's all set forth in case law. So disciplinary process, the handout, which I provided this morning and which Salwa talked about on the record before we began, there are copies here. Really what they're here for is to show you a bit of where the different offices are in the state. We have 4 OH offices in the state. We also have 5 Attorney General's offices that kind of fit into those 4 offices. And then the last page is a flow chart. And so really what this is to express to you is this takes time. Due process requires that the rights of a licensee as they go through this process are met. That's receiving discovery, reviewing discovery. Due process allows the licensee to hire their own experts to review the evidence. Due process allows the licensee to receive that evidence and test it. Due process allows the licensee to have a hearing, because if the board takes enforcement against a licensee, or if the board denies a license for an applicant, the board is obviously impinging on important property rights, the right to carry on in your profession. And so before the board can actually either prevent a licensee from getting a license or before imposing terms of probation on a licensee or an applicant, the board has to go through a very lengthy due process system, which is set up under the APA, the Administrative Procedures Act, which we've been talking about a little bit, and that's in order to protect their rights. And so, yes, this does take time, and we recognize that. I know that board members and the public are very concerned about how long a case takes and how long this process goes forward. We at the Attorney General's office do everything we can to move these cases as quickly as possible. We provide reasonable updates to Ben on a quarterly basis regarding where cases are in the pipeline, what the age of a case is, how long it's taking, and we highlight cases if there are issues to try to move cases along. We object to most continuances, and we will only agree to a continuance with Ben's express approval before we agree to a continuance of a hearing. We try to move the process along. We try to make sure the pleadings are done quickly, and we work with Ben, and Ben works with us to make sure that that occurs in a timely basis. But I would point out that as this flow chart shows you, and even as this is listed here on the slide, which really the flow chart is just representative of that, this does take a long time, and there is time built into this. And in many ways, everybody, including the legislature, including the public, including the board, everybody's always trying to push to make sure those times are done as quickly as possible. And there's always pushback, because there is a certain point where due process dictates the amount of time something will take and making sure that all the steps are met. Okay, we've got the different players in the process. Attorney General's office, as I said, was carrying out the enforcement sought by the executive officer, as the executive officer is the complainant. DCA legal counsel advises the board. The board makes the decision. So there's another slide that we're going to have a little bit on this. But the ALJ facilitates the hearing. So when I go in front of an ALJ, or when a DAG goes in front of an ALJ, separation of powers here. We have an administrative law judge who's working in the judiciary function. I don't have ex parte communication. I am a party, a represented party. You're representing Ben in front of that board. The licensee has an attorney who's representing it, and we have a trial, an administrative hearing. After that process, when you are determining the penalty or disciplinary penalty on a case, or reviewing the decision or reviewing a stipulation, you are acting as the judiciary officer at that point. The board, so separation powers continues again. While I will be representing Ben, the complainant, as the executive officer, your office will be acting as the judiciary function, which means I won't be having ex parte communications with you on decisions after an administrative law judge has made a decision. The only way I can do that if a stipulation's in place is before a closed session where all the board members are present and we can discuss potential stipulations. But even then, it's very defined. I can't be there when you start discussing afterwards what your actually decision is going to be, because justice is blind. It's a separated process. And so that's where that is. All right, and so that is 28 minutes and 50 seconds. That came in a minute under, so I think that's pretty good. I have 15 minutes or so, or whatever, if there's any questions. If I can answer anything about the presentation. I know that this is a thumbnail of enforcement, but that way you have an idea of the role of the Attorney General's office in this process.
Any questions from the board members? Thank you very much, John.
Thank you very much, everybody.
Thank you. Public comment?
We heard earlier that there was going to be more leniency.
It would actually be helpful if you stepped up to the mic. Sorry, Ron.
My name is Neil Miller. I'm representing CalAtma, California's Acupuncture and Traditional Medical Association. Ethics and unprofessional conduct is a very serious issue that we want to work closely with the board to be on the preventative side. And we wanted to let you know that, and to be able to reach out to you and to us and have an open line of communication to put this to an end. One of the issues that we're reviewing a lot of the disciplinary cases, and we just saw a case where an acupuncturist did not have a bell, a buzzer, or an intercom. And I can tell you that from talking to a lot of acupuncturists, nobody has a clue that that is unprofessional conduct, that you need to have that. So that's an example of some of the things that we want to be able to communicate to our members and to the other practitioners from the board. So we hope going forward that we'll be able to address a lot of the issues that are already on there, and most of these can be prevented with better communication. So we're looking forward to working with the board on this issue. Thank you.
Thank you.
Ron Zeidman, Five Branches University. In an earlier presentation, if I heard correctly, there was going to be more leniency in taking away licenses from practitioners. Is that going to change the role that your department is going to be playing?
I guess, is this question that's being directed to me, or is this question being directed to the board?
I think it's just public comment.
It's just public comment. It seems to be directed to the AG's office. I suppose it's up to AG's office
Mike.
whether they want to respond.
I mean, my response would be simply that leniency comes from the board itself. And so the Attorney General's office follows the dictates of what the executive officer sets forth. And so I'm not aware of leniency, and so I don't know what you're really referring to.
No, wasn't the bill 2138 addressing that issue?
Well, 2138 really addresses license applications. So 480, 481, 482. There is some change in how it's going to be for disciplinary process, although not as much, because there's a timeline on 2138 of 7 years. It really has to do with license applications.
Any other public comment?
No? Okay. So we will take probably 15 minutes. Sure. Let's do 15 minutes break, so we will be back, reconvene at 11.
Thank you.
Thank you. Yes, okay. Good? Okay. Okay. So now let's move to agenda item 7. Time is 11:04.
Thank you.
Thank you. Review and adoption of October 25 and 26 board meeting minutes.
Would you like me to leave that?
Yeah, sure.
Thank you, Dr. Matecki. Before you, members, we have the minutes from the last meeting held in October. It is not necessary for the members that were there to all be here today to approve the minutes. So everybody here can look at these and motion and vote on it. Are there any questions or comments from the members? Any items identified that was incorrectly typed? No? We're good? Is there a motion on the table?
I'll move for approval.
We have a motion to approve the minutes by member John Harabidian. Is there a second?
I second.
Dr. Amy Matecki seconds. Public comment? Seeing no public comment, let's go to a roll call vote. Ms. Brothers?
Yes.
Chan is absent. Chimino?
Your mic.
Chimino? Oh. I thought it was on. Chimino?
Yes.
Yes.
Okay. Harabidian?
Yes.
Kim?
Yes.
Lee?
Yes.
Okay. And the motion passes, and that's 5-0.
Thank you, Ms. Brothers. These minutes are now approved.
I don't think Osario was called.
Oh, I apologize. Osario is absent.
And Chan is called too?
Yeah.
Mhm.
Thank you. The minutes are approved.
Thank you. Let's move on to agenda item 8, board committees and member assignments. For Education and Research Committee, Chair John Harabedin, Member Francisco Kim. For Licensing and Examination Committee, Chair Kidman Chan, Bradley Cimino. For the Executive and Legislation Committee, Chair Ruben Osorio, Amy Mateki, Member. For the Enforcement, Chair Francisco Kim, Member Shudong Lee. So for the next few items, we moving from Friday. Oh, any public comments? Sorry. No? Okay. So for some of you maybe early weren't here, we have a few items changed due to the board members' availabilities. So we moved the closed session to tomorrow. So now we will move Friday's item 5, 7, and 9 to current. So executive officers report, update. And Ben, please.
Thank you, Dr. Mateki. The first item is a staff update, and I am happy to announce that we have been able to hire 2 managers. And some of you may know our new licensing manager, Jay Hurt, has been with the board as an education coordinator as well as an expert consultant, and is now our licensing manager. And our new central services manager dealing with administration, policy, legislation, regulation is Matt Nishimine, who I've had the pleasure of working with for the last 2 years as well, liaising with the budget office. And I am very happy to have them on board. Welcome, gentlemen. The second item is vacancies. As you can see, our board members all the board member positions have been filled. However, we now have several vacancies on the staff. Currently, there are 4 vacancies. You may notice that Ms. Brothers is now our policy coordinator. Mr. Johnson has left for working with the optometry board, and we wish him best of luck there, and welcome Ms. Brothers to the policy position. Additionally, our seasonal clerk position is vacant, and we are currently hiring for that, and an administrative technician as well that we're hiring for. And then we have a vacancy in the enforcement unit. So we are currently down to just 1 analyst in our enforcement unit, and we're grateful for Cricket Borges for carrying the load while we are looking to fill this spot. Any questions or comments from the board at this time? I will proceed to the budget update. And here I would like to call our Central Services Manager, Matt Nishimine, to provide us the information for the next 4 items.
Thank you, Ben. Good morning, Board. I'm happy to be here in front of you again, but this time as a staff member of the Board. I'm going to be talking about a few things today, and we can start. If we go to tab number 5, the EO report, and there's a budget summary document here. Are we all there? Okay, so this is a one-page display. It's going to show all the changes to the current year, which is the 18-19 year, and then the proposed budget year, which is the 19-20 year. That's why we're seeing 2 columns on the right. So this document is going to identify all the base level adjustments that were made to our budget, and we can go into them in detail now. So the governor's budget is statutorily required to be released January 10th of each year, and it's going to look something like this. This is the entire department's budget. In this document, the Acupuncture Board is known as 1155, so that's what that 1155 is. That's our program number. Our item number, which is the 1111-001-0108, is the identifier that's actually in the budget bill or would be in the Budget Act. So when the actual money that is appropriated is going to be tied to that item number. If we start at the top, on the left, it says 2018 Governor's Budget, and the amount is 3354. So that was our base level that was proposed in the 1819 Governor's Budget. Then just going down that 1819 column, there are a few adjustments. It says Change Book, Governor's Veto. So from the Governor's Budget, it's a proposed budget, and the legislature has an opportunity to weigh in on those incremental changes. So it says Ledge Action, OCM positions for pro rata analysis. So as part of last year's legislative session, the legislature required DCA to do a analysis of its pro rata. And pro rata are the fees, the fees that boards and bureaus pay to DCA for the centralized services. And so that's what the $1,000 is. That's our contribution. The board's contribution is $1,000 for that analysis. Below that is says Ccsd technical reduction, SB 173. So that was a bill that removed the Bureau of Real Estate from DCA, and it made it its own agency. So as part of that, there was a compromise, and there was a budget change proposal that was included, and the agreement between the administration and the legislature, the compromise, was that DCA would also reduce some of its centralized services. And so it's a 3-year project to reduce those centralized services. Our contribution is, total pro rata contribution was reduced by $4,000, and that's what that minus $4,000 is. So we're ending, our 2018 Budget Act appropriation was 3351. So if we start that as a 3351, think of the budget, we do incremental budgeting, and we do it in 2 years. So we're going to make adjustments to the 1819 budget and then to the 1920 proposed governor's budget. Moving down this column, it says one-time full-year cost adjustments. There are none in the 1819 column, but there are some adjustments in the 1920 column. Again, there's a minus $2,000 for the SB 173 implementation, which is going to be, so we'll have another one in 2021 also. It's a 3-year implementation. The Ledge Action, OCM pro rata analysis. So this is the analysis that was referred to up above, but we're actually getting a minus $8,000, and that's due to the one-time costs that are included in that proposal. And then there's an OTEC cost redistribution. So that is Office of Tech, that's a centralized adjustment that from a previous BCP, and so our incremental adjustment went up $2,000. The next line are baseline budget adjustments, and these are typical adjustments that are made every year. And so they are related to employee comp agreements that the administration has with the various bargaining units, retirement benefits, equipment adjustments, and then there could be other internal adjustments as well. So if we just look at them, our contribution for retirement went up by $10,000 in both years. Our employee compensation adjustment went up by $57,000 in the current year and $58,000 in the budget year. And then other post-employee benefits. So this is an adjustment dealing with bargaining units. Moving down, equipment, net, it says $12,000 in the governor's budget in the 1920 column. So this is an adjustment if the board seeks to buy a copier or a large scale, a large equipment, that's that allocation. Department distributed costs. So this is the pro rata cost that I referred to earlier. These are for DCA centralized services. Our contribution actually went down by $61,000 year over year. And then you can see the incremental adjustments. So for the Office of Information Services, it went down by $27,000. For the Admin Exec Office, it went down by $3,000. D of I, which is the Division of Investigations, it went up by $7,000. Communications went down, and program policy and regulations went down too. So our contribution is less by $61,000. The next line item is budget change proposals. The board did not submit a budget change proposal for 1920 during the fall process. However, the department did, and it says department-wide, and there's a $44,000 contribution. I can go into greater detail in a few minutes, and that full BCP is actually in the package. So we'll be coming to that in a minute. Still moving down, it shows that in the 1819 column, there's 3432, so that's our revised appropriation level. And then we also have the ability to collect reimbursements. We're scheduled to collect $23,000 in reimbursement authority is our official authority. So our net appropriation is 3409 in the current year, and our proposed budget is 3397 in the budget year. Moving down further, it says positions. There's a 10.5, and then there's an authorized positions, 12. The difference between that is, and there's a little asterisk, it says budget transparency for display purposes only. So the 10.5 is what, on a 3-year average, that's what the board has been carrying as far as staff. So that would be full authorized plus temporary help staff. We are actually authorized 12 positions, so on average, we've had about a 1.5 vacancy over the last 3 years.
Can I ask a question about that?
Yes.
So if we're authorized to have 12, does the budget, the 3.4, actually include money for that?
Yes, so we have a personal services budget for staff, salaries, and for their benefits.
Okay. So it's not only authorized, it's budgeted for a full 12.
That's correct.
Okay.
That's correct. And so, to further that point, these incremental adjustments for employee comp and for retirement are based around the 12 positions that were authorized.
And if I may add, so sometimes you may see some cost savings, like from past years, because of the vacancies we've had. Yeah. And this gives us authority to spend money we have. It's not coming from any other fund. It's a special fund from our licensees.
Any further questions on this document? Okay, we're going to come back to this many times. You'll see this document many times, but we can turn the page. This next page is a fund condition statement, and a fund condition statement accompanies every governor's budget. It's in the back of the governor's budget. This particular one shows 6 columns, or 6 years, 6 fiscal years. Typically, you'll see 3 years in the governor's budget. But we did this to project out the horizon, and I'll explain in further detail in a second. It's important to recognize that a fund condition statement is a living document, and it's going to change upon the best available data. I'm one that I don't like to change numbers, but in this case, we go with what's actually coming in, so it will change. So just be aware of that. What a fund condition statement does is it's basically like a checkbook. It's going to show you your revenues that are coming into your account plus minus your expenditures. So if we just look in the revenue section, we have several different revenues that the board brings in. So it'd be license fee revenues, it could be site and fines, renewals, delinquent fees. Any of those fees are going to be captured there. You can see that the majority of our fees are based around renewal fees. Moving down, there's another line. It says transfers from other funds, and there's 1,000 there in the 1920 column. These are in thousands, so that's $1 million. So that $1 million was a general fund loan from 2011 that was repaid, is planned to being repaid in the 1920 year. Moving down, these are the expenditures that not only the board has actual and projected expenditures, but then it also has some other line items. For the fiscal system, that is the statewide accounting system that we pay into. We actually got $1,000 back, which is good. Supplemental payment, pension payment. This is a adjustment to that the previous governor made with bargaining units, and so we're paying into that. And then the last one is statewide pro rata, and these are the costs for the governor's office, our agency, the Business Consumer Services and Housing Agency, Department of Finance, anything under the administration's umbrella. In this document, it's showing that in the 17-18 column, if we go to the bottom under the department, there's a number 2814. While we have not closed our 17-18 fiscal accounting books yet, we are estimating that our expenditures were $2.8 million last year. And we will be closing, we anticipate to be closing very soon. Just moving to the right, there's a number 3312. That's what we're projecting the board to spend in the current year, in the 18-19 year. And I'll go into further detail what makes up that number. And then just continuing to move to the right, there's a number 3397 in the 1920 column. That is our proposed budget, and so that is going to tie directly to the governor's budget. If we go all the way to the bottom, there's a line that says months in reserve. And we can see that it's going down, 14, 10.8, 10.6. It's declining. And then we've extended this horizon because in 22, 23, it shows a negative. Well, we can't go negative. We would have no money. Basically, months in reserve is saying how many months, operating months, could we operate if our revenues went to zero. A prudent reserve is about 6 months. So while we've had a healthy reserve, actually an over-healthy reserve, and that was part of the reason why we had to give the general fund loan, because we're statutorily capped at 24 months, and we were in excess of that in the past. And so what we're seeing here is a structural imbalance where our fees are less than our expenditures, and that's why our months in reserve goes negative in the out years. Another thing to consider is this is just as status quo. So as a previous presentation with our business modernization plan, our computer program, our computer system, that's going to cost money. That's not included here. So to the extent that that's included in the near future, that's going to exacerbate this problem. Any questions?
I just wanted to point out that in the budget year 2019-20 column, you do see the loan repayment happening there, correct? Yes.
That's correct. Right in the middle. It's
Right
right in the middle of the page. It says 1,000.
And that is the last loan we have out to the general fund.
That's correct.
And it will be returned, projected next year.
That's correct.
I do have a question about that. I know we've talked about this at previous meetings, but because of what you pointed out is our licensing revenue is no longer sufficient to pay for our costs. I know that we are planning to adjust the licensing fees. So when do we expect that to, at least that process to go into play, to try to get the revised fee schedule, I think it is, right?
Right. So that's actually
sorry.
my third button, but we can talk about it.
No.
So actually, for my section, 1, 2, and 3, we can all they're all commingled. So I can talk about this fee update. So now, so we have entering into a contract with a third-party vendor. We had to put the bid out to contract. We put it out to 3 CPA sort of consulting business groups. Of those 3 contracts, we went through and settled on one, and the DCA contracts unit is finalizing the contract. We should be beginning that fee audit in May, probably late April or May is what we're anticipating. And that process will take two or 3 months, so it'll go through the summer. What he's going to do is he's going to look at all of our current fees, and our fees pay for different things. So initial license fees are basically have to pay for the support of those fees, the processing of those fees. Our license renewal fees can target other programs such as enforcement and other costs. So at the end of the day, we do want to eliminate the structural imbalance. We're thinking that 2021 is our target date, January 1, to have them effective in law. So the reason we're doing this fee audit is because our fees are statutorily set and they're also set by regulation. So we need this third-party entity to go basically before the legislature and show them that, yes, this is the proper level for our fees to sustain the board. Let's see here. So we will be, based on the findings of the fee audit, we plan on including them in legislation in next year's legislative session. So we would find an author to carry that bill and include all of our fee adjustments. As you can see, we're about $1 million as is right now. We're about $1 million. The imbalance is about $1 million. But again, it does not include the IT project.
And from a historical perspective, our fees haven't been raised in
many years. And so this is a good time. We've been planning this for some time. I've been working with Ben on planning this so that January 1, 2021 target date is met. We'll also be running regulations to adjust those fees. I think what we're planning on doing, ideally, we would have a range set in statute for our fees, and then we would follow with regulations to set a specific fee amount. And that will allow us for future growth or for future projects. Any further questions on that? Okay. We can turn to the next page. It has these colors. And I'm going to talk about my item 2, which is Architecture Revolving Fund, or ARF. Okay. So this document is a nice document, and the DCA Budget Office provided us this document. What it does is it's showing the historical expenditures going back to 2015-16, 16-17, and 17-18. Those are colored in the blue and the sort of orange and the purple. And these are all of our line items, our budgetary line items. So as was previously asked, what is our personal services budget? That would be the yellow column there. Our personal services budget for the current year, 18-19, is $1.2 million. And then everything below that are general expense items, operating expenses and equipment, mailing, printing, travel costs. It also includes the department's pro rata, any interagency services, our cost to implement exams, and then enforcement-related costs. So that would include the Attorney General, Office of Administrative Hearings, and the Division of Investigations. looking at the previous years, we see that we were spending, well, last year we spent 2.9 million. So there was quite a bit of savings. I think we were authorized 3.4, so we had quite a bit of savings. If we look at the yellow column, and to the right, so the yellow column is what we're budgeted at. Moving just to the right of that in the white column, it says pre-FM7. So this is through fiscal month 7, through January. These were the actual costs that were incurred by the board. Now, I say that with one caveat, because the DCA is switching to the fiscal system. Several years ago, the state brought on a new accounting system. It's an accounting, budget, and a procurement system, the fiscal system. And right now, we're not getting all of the data out of the system that we like. So you can see some of these numbers are a little bit low. And so you might think, well, how did they extrapolate that? So let's just give an example here. Under general expense, there's a number 6842. That's what the system is telling us. But we know that historically we've spent more than that. And if we go to the left on that same line, we spent 44,000 in 15-16, 55,000 in 16-17. Last year we went down to 12. So we're anticipating about 37,000 in spending for that general expense. In the far right column, you'll see some numbers are red and some numbers are black. If it's red, that means we've exceeded our budget for that line item. Now, there's no cause for alarm if we see red, because the state balances at the bottom line. So individual line items can be exceeded, but so long as we stay within our total allotment. Now you may ask, well, why don't you square this up? Why don't you move some of these numbers around? And so we are in the process of analyzing our data. Again, because of the recent move to the fiscal system, some of the old historical numbers are now moved to different categories. And so we want to figure out what our actual run rate is, and then we will make an adjustment. But we'll probably do that in the next year or so that you won't see these reds, or you'll see less of them. There are two lines that are highlighted. One is the Architecture Revolving Fund. That's about in the middle. And if we just go to the right, it says 250,000. So what is an ARF? An ARF is a place for us to deposit any savings that we have. So during this current year, if we had taken that 250 out, we would have a surplus of an additional 250. But recognizing that, and recognizing that the board would like to make some tenant improvements to our suite, we are putting this money in this architecture revolving account, or fund, which is set up by the Department of General Services. So we're working with the facilities unit and DGS to come up with a plan to reconfigure the office space suite. One of the things that, if you've noticed, if you've been in our suite, we have one door, one entry. So we're looking at maybe putting a second door in. We're looking at maybe putting in a small break room for the staff. We're looking at maybe reconfiguring some of the cubicles. We don't have the plan yet. We have a lot of ideas. So we will be working with the Department of General Services and the DCA Facilities Unit over the coming months to solidify that plan. $250,000 may or may not pay for all of the tenant improvements that will be included in our plan, but we're able to put this money away now and use it at a future time. If we didn't do this, that money would return to our fund balance would go up, but we would no longer have access to that money. We would have to seek a separate budget change proposal for those facility costs. So this is sort of planning for the future. There's another highlighted item a little bit below that, says data conversion, DGS project. So this is another project we're working with the Department of General Services. to convert our file room, to digitize some of the items in our file room to a digitized platform. And we are working with DGS now and the DCA Facilities Unit to finalize those costs. We think that once the bids get in, then we're going to prioritize what we want to digitize and what makes more sense maybe not to digitize. So that number may change too. If we include both the ARF and the DGS data conversion project, and we go all the way to the bottom, it's showing, the bottom right corner, it's showing that we'll save about $91,000. So again, we're under budget, but we're planning for the future.
Any questions from the board members?
Okay, so the next item is the budget change proposal. And if you remember, on that summary document, the first document, there was a DCA-wide budget change proposal, and our contribution was $41,000, or $44,000, excuse me. So that's what this is, and I'm going to go over this briefly. So we included this so that the members could see what a budget change proposal is and what the purpose of a budget change proposal is. So if a board wants to make an adjustment, wants additional resources, you have to submit this document to the Department of Finance. So a board would work with the DCA Budget Office to craft a BCP. And again, we do not have a BCP this year, but we did in the previous year, and that was the one to get our licensing manager position. So we do have a recent BCP. This is the DCA-wide BCP, and so it's a consolidated BCP, and it's allocating about $5.2 million and 24.5 positions over various units. If we look, so this first page is just a summary page. Again, it's a Department of Finance document. At the bottom, you can see that it's originally signed by Tiffany Garcia. She is our DOF principal. She's our contact at the Department of Finance. And then she dated it 1/10/19. So it was consistent with the release of the governor's budget January 10th. So typically, the BCP process begins in the summer, goes through the fall. These are submitted to the Department of Finance in the early fall. The Department of Finance will vet these, ask questions, goes back and forth between the programs, and then if they want to approve it, they can approve it, and then it's included in the governor's budget. So this one is in the budget. Again, it's about $5.2 million and 24.5 positions. If we turn the page to page 2 of this BCP, there's lots of numbers here and lots of lines. On the left side, again, it's just going to show the summary of the 5.2 and the 24.5 positions. But what's nice about this document also is it's going to show all the contributing boards and bureaus. And so we are Fund 0108, Acupuncture Fund. So we're the second line there. And then that's showing our contribution of $44,000. But you can see all the other boards and bureaus participated in this to fund this proposal. I'm going to turn the page again, and there's a narrative section there on the right side of your book, and under the background history, section B, there are some bullets, and these are the different units that are receiving proposed funds and resources. So the business services, the fiscal operations, they're requesting 2 positions and 7 positions, 1.2 million and 7 positions. And these are to support the fiscal system, fiscal operations, and their accounting systems. Legal Affairs Division is requesting $1.67 million and 6 attorneys and some other legal staff. And this is to set up a regulations unit. The Division of Investigation, so these are our enforcement, this is the sworn officers of the department. They're requesting $2 million and 4.5 positions. The Office of Human Resources, they're requesting $46,000, but no positions. They want to convert some temporary help positions that they have to permanent staffing. And then the Office of Professional Exam Services, they're requesting $287,000 and 2 positions for increased workload there. So this consolidated BCP covers the 5 different units. And in doing so, it's going to increase the boards and bureaus' pro rata cost or contribution that we would pay. Our contribution is going to be $44,000 in the budget year. So we don't have to go into all the detail of this budget change proposal, but it's informative. The DCA Budget Office has a proud track record of producing really exemplary budget change proposals. The DCA Budget Office has a high success rate of producing successful budget change proposals, and that's because they know how to put these packages together. And this is a complete package. So it goes into narrative. It's justifying each one of the sections that are requesting. It's going to provide workload. It's going to provide analyses of why and why not they may not need this. It's going to give alternatives that maybe they considered. So you can read through this, but it is a good example, and so that's why we included it.
Any questions from the board members regarding the DCA-wide budget change proposal? This was to familiarize you, as Matt said, with this whole process. It's a very long process. We're applying over a year in advance, almost a year and a half in advance. So we really have to be forward-thinking when looking at how we will be planning out our office, and also the importance of that architectural revolving fund. We want to be able to plan for this since it takes so long to be able to get our budget changed. Okay.
Oh, and I would just add about the ARF. In the event there is unspent funds in the ARF, it just returns to our fund.
Yep. Thank you, Matt.
Thank you.
Thank you.
That takes us to item C for the Executive Officer Report. And this is the outreach update. And the first item is the 2019 Chinese Medicine Day. The board, I as the Executive Officer and Jay Hurt as a staff person were invited to attend the March 17th festival on celebrating Chinese Medicine Day, the 90th anniversary. And everybody gathered to celebrate this long tradition. And it was attended by many members within the Chinese medicine community. And it was quite a festive event. It was just a couple hours. So we are grateful for being invited and included in that community. Any questions from the members regarding that event? No? Thank you. For the second item, the Nccm certification for California licensees. Earlier this quarter, the licensing manager, Jay Hurt, and I met with NCCAOM Representative Dr. Corey Ward Cook, where we discussed the linkage studies coming out of the NCCAOM. We also discussed the timing of the board's occupational analysis. Both of these studies and analyses dictate the kinds of questions that are used in future iterations of the exam. The board and the NCCAOM have been comparing theirs for proper psychometrics. And equivalency. We also reviewed the NCCM certification route for California licensees. NCCAOM has reached out to its participating states that require their examination, and they have put the route that they have provided California licensees before each of those states. And so the states are now determining whether or not they will accept just the certification as opposed to requiring the examination of all 4 modules for that. So we, at this moment, know that Washington State has determined they will not accept this, just the certification, and they want the test, the full examination as well. As more states make a determination, and CCAOM, Dr. Corey Ward Cook, told us that the organization will be updating their website. So I urge you all that are interested in this route to continue to check on the NCCAOM's progress in hearing back from the states. Any questions from the board members? Thank you. The last item under the outreach update, if you turn to the booklet under tab 5, the last section just before the legislation update, you will see a project that the board staff have been working on with the department's Office of Public Affairs and Office of Publication, Editing, and Design. And what we wanted to do is to really be able to explain to our stakeholders and to the public at large what we do and how we do it. So what I did here was paste 4 pages of a booklet on one page just to save some paper, but this is actually a little 5x8 booklet that really explains all of our functions. This will be made available as a PDF for folks to print, for licensees to print or associations to print should they wish to distribute that. And the board will bring some of this material to public events that it goes to. Should the board members be okay with this release?
Yes.
Okay. Any questions on the content that is presented? I would like to point out that it does break the board down structurally by the units or the desks that it comprises of, as well as the contact information directly for those units. So if you have an examination question, you can contact the examination unit directly. If you are a training program, you have a specific address to contact our representative directly. You don't have to go through the general mailbox. The same thing with enforcement, continuing education, and tutorials. So we've really tried to tailor this. This kind of email system allows for staff changeover without loss of communications. So we urge you to use this method to communicate with our staff. And that is the end of who we are and what we do. Public comment on any of the items issued in this section.
Yeah, Jacques Marmarco, Emperor's College. Just a clarification in New Mexico right now. They have not approved it. However, they're going to have a meeting in May for the national exam for the reciprocity. So I have a colleague of mine that petitioned the board, and he's in constant communication. So they're going to make a ruling in May. But as of right now, they want the exam. That's for New Mexico.
Thank you.
Neil Miller, CalAtma, California Acupuncture and Traditional Medical Association. NCCAOM, the board deemed that it was psychometrically equal to NCCAOM. Is that correct, that our tests were psychometrically equal?
On some fields. There are other areas that are not, yeah.
Okay, because the Veterans Administration only accepts NCCAOM, and we're trying to, if our test is equal or above that, is there anything to recall in previous meetings that articulated that so that we could take that, and we're trying to talk with the Veterans Administration about accepting the CAB because it's equal to or superior to that test. We could send you a letter to see if there's something that was discussed and it was determined so that we could get some response from the board that says that it's equal in these areas where it's, we are equal or above that, something like that.
I can answer that question right now. I would recommend that you take a look at the audit report that was done in 2015. and that lays out exactly where it meets the CALE or if it does not meet the CALE. And it's a public document. We have it on our website, and it's official.
Great. And who we are and what we do brochure. The board used to send out an update all the time to different people. And they also used to produce the consumer guide to acupuncture. This is not the consumer guide to acupuncture. This is something different, correct?
That is correct.
Okay, so I'll bring that up under new business. Thank you.
Thank you. Any other public comment on the EO report? Seeing none? Dr. Matecki?
Okay, thank you, Ben. So now we go to the item 7, the regulation update. Christine Brothers, Policy Coordinator, please.
Hi, board members. So this is an update on the regulations that the board is going to be working on during the 2019 calendar year. And so below is just a list of that. And it may not be complete. It's subject to change depending on the legislative or executive action. The due date reflects the final due date when regulatory filing is anticipated to be submitted for rulemaking to the Office of Administrative Law, or OAL. So the first regulation that's listed is on AB 2138, which has come up previously in the meeting, and it's in regards to the denial of applications, revocation or suspension of licensure for a criminal conviction. Tomorrow's board meeting, we will be bringing the proposed regulatory text for discussion and possible adoption. Patrick Lee also indicated that there's kind of a tight timeline that DCA has put out, and we're trying to adhere to that. So hoping to have that filed by August 2019. The second item for pending regulations relates to Senate Bill 1441, the implementation of uniform standards related to substance abusing licensees, and our update of our disciplinary guidelines, which was also brought up earlier in the meeting. And that will also be brought to the board tomorrow, and proposed regulatory text, as well as amendments to the disciplinary guidelines for your review and hopefully possible adoption. And we also would anticipate or hope to file that with OAL by August 2019. The third item, Senate Bill 1448. This becomes effective July 1 this year. And actually, this is on disclosure of probation status to patients, and is only affecting licensees that are on probation. And the implementation of this would be through our disciplinary guidelines as a probationary condition, which we'll also go over tomorrow's board meeting. Again, if it goes through with the disciplinary guidelines, the anticipated filing date is also August 2019. The fourth regulation is Senate Bill 1246, which is aligning curriculum standards and approval related to regulations with the statutes. And this bill went through some time ago and changed some of the terminology with our approval over curriculum versus training programs, and our current regulations don't really align with that. So at this point, staff has identified some of the problematic language and working on drafting amendments. And we anticipate a December 2019 filing date. And the last regulatory package on our rulemaking calendar is AB 2190, and this is on the application process, criteria, and procedures for approval of a credential evaluation service. In the past, staff has worked on developing proposed regulatory language as well as applications that it would relate to. That's under review, and so possibly a December 2019 filing date on that as well. And I also wanted to point out, earlier, Matt had talked about the DCA-wide BCP, the budget change proposal, and relating to the new staff within legal affairs for a new regulation unit that will be established. And the idea is that they would work with boards in establishing a more comprehensive rulemaking calendar and timelines for staff to meet and to adhere to. So that's on the horizon as well. Any questions at all?
Coming back to item number 4, just a little bit more background. SB 1246, we already have passed some regulations to move to approving curriculum as opposed to the programs itself, as Christine has provided. They're just loose ends. So when a statute is placed changing something where there's already regulations established, it tries to capture what's necessary, but the board has to go back and clean up any authority references or loss of authority. So we're going through and clearing, tying up any loose ends there. And then for the reg package number 5, AB 2190, this is from 2016. The board has been working on this, although SB 1246, disciplinary guidelines, and 2138 were more pressing. But the board is actually communicating with evaluation services, and we are seeking to develop the standards that the bill or the legislation requires. So we will be continuing to work on that as well. Any questions from the members? Okay.
Thank you. So we have education. We want to coming back, or how we want to do this?
What time is it?
It's 12. Yeah. Should we take a break?
You can ask the board.
Yeah. So we have. Okay. So we have the education report and committee work. Should we want to take a break now, or should we just continue?
Yeah.
Should we want to take a break, or should we just want to continue for the education part? We can do education update report.
I'm fine with
Okay.
whatever people want to do. I mean, I don't see the lunch isn't here yet, so.
Right.
So
Okay.
maybe we should just keep.
Let's do it.
Keep going for now?
Okay.
Okay.
So let's see, this is item 9. So currently, we look at is all the Friday. On Friday, the item 5, 7, 9. So now we come to education report from Jay Hurt, licensing manager. Please. Public comment.
Jay, 1 second. Can we back it up for public comment on the regulation packages?
No problem.
Oh, you can stay right there. It's not gonna. Seeing none? Thank you, Jay.
Wait, quickly. Hello, everybody. I'm Jay Hurt, the licensing manager, and I'm going to give you the education report. And we're going to move on to CEs later. So to start with, the board's oversight of acupuncture training programs. There are currently 35 approved acupuncture training programs as defined by Business Professions Code, section 4927.5A. And in regard to that, the board took on doing compliance reviews on all the current schools that were able to qualify people for the licensing exam. And so this first part is speaking to that particular process of the compliance review. So to date, the board has completed 28 program reviews that are in full compliance. And it's an exhaustive list. I'm not going to read through them right now. There are remaining 7 training programs that need to be reviewed, have submitted their curriculum to the board, and also clinical corrective actions that they've responded to past site visits. And those are pending staff review of their curriculum. And I'll note that all of these institutions are out-of-state institutions. And I'm going to just read them off since they are still in a compliance process with it. There's the Austin Oriental Medical College in Austin, Texas. There's the American College of Acupuncture and Oral Medicine in Houston, Texas. And just note, there's a slight correction there. It was incorrectly quoted as American College of Traditional Chinese Medicine, Houston, so the true name of that one is the American College of Acupuncture and Oriental Medicine. Bastyr University in Seattle, Washington. National University of Natural Medicine in Portland, Oregon. New England School of Acupuncture in Worcester, Massachusetts. And then the Southwest Acupuncture College in Santa Fe, New Mexico, and then their sister campus, Southwest Acupuncture College in Boulder, Colorado. There are currently 3 first professional doctorate programs that have been approved by the board that met our curriculum requirements and the other requirements of BPPE and an accreditation from ACOM. These institutions are the Acupuncture and Integrative Medicine College at Berkeley, California, and their program is the Doctor of Acupuncture and Integrative Medicine. Southern California University of Health Sciences in Whittier, California has been approved for a first professional doctor for their Doctor of Acupuncture and Chinese Medicine. And then the University of Bridgeport Acupuncture Institute in Bridgeport, Connecticut, it has been approved for their doctoral program in its Doctoral of Traditional Chinese Medicine. And it's just interesting to note the differences in titling. The accreditor allows the programs to choose their own titles for their accreditations. So it seems to be settling into the DACM, DTCM with a little bit of the DAIM is a little bit of an outlier. But they do actually for their post accreditation or their post doctoral degree is required to be called a DAOM. So there we go. Okay, and then there's one school that lost approval of the board, which was Southern California University School of Oriental Medicine and Acupuncture, Los Angeles. And the program ceased operations in December 2018 for forfeiting board curriculum approval status. This was voluntary on the part of the institution. They had worked through their curriculum approval with the board, but they found struggles with completing their accreditation process with the accreditor. So they're no longer approved by the board. New applications for board approval of curriculum. The board has received a total of 2 applications for board approval of curriculum in the second quarter of fiscal year 18-19. The curriculum applications are currently under review are for the American College of Traditional Chinese Medicine at the California Institute of Interlocal Studies, and it's for their first professional doctorate of acupuncture and Chinese medicine, a DACM. And then also there's an application from 5 Branches University for both of their programs, Santa Cruz and San Jose campuses for a first professional doctorate. And their doctorate is titled a Doctor of Traditional Chinese Medicine. These applications currently have exceeded their statutory mandatory 30-day statutory review requirement. This is due to a temporary staff vacancy and is anticipated to be a temporary backlog. Both applications are from programs with existing approved curriculum in their master's program that are either identical or embedded with the applicant doctoral program's curriculum. So as a result, students completing these programs will have met the curriculum requirements, enabling these students to qualify for the California Acupuncture Licensing Exam. And then moving on to approved programs that are wishing to change their curriculum. In order to apply for curriculum change approvals, after January 1st, 2017, education and training programs are now required to complete an application for board approval of curriculum to make these changes. And typically programs are averaging about 3 submissions to move those applications through the board approval process. And then mentioning we do have one institute, Whitewater Institute in Cupertino, California. It's received curriculum approval from the board in the Q1 18-19, showing full compliance with the board's requirements. However, Whitewater currently only meets one requirement that's required for approval of education training program, and that's the board curriculum approval. They still do not have the approval to operate from the Bureau of Private Post-Secondary Education. Nor have they established accreditation status from the Accreditation Commission for Acupuncture and Oriental Medicine, which is a required accreditor for approval. And just to note that all these 3 requirements are required to qualify for the test, but currently there's no agency that supervises all those coming together. And so this is mentioned to say that they have a quasi-approval, but they don't have other approvals. And so it does give some oversight concerns, particularly from our point. So even though we're not charged, we've been tracking this to keep it in order, and we need to be able to verify that for the test. So this is one of the areas that we're talking about cleaning up too. So and then I'd like to, so one more update too, that there are a number of schools that are approaching, that are approved by the board and can qualify for the California Acupuncture Licensing Exam, but they're approaching a 3-year pre-accreditation deadline with the accreditor ACOM. And if they're not able to meet that, and they fail in their accreditation, then they'll also lose accreditation from the board. And so we're tracking that. We're working closely with ACOM. We've had no problem with communicating where programs are at, and they've been very transparent with us in establishing the dates of these timings. So we really appreciate our collaboration with ACOM. So then moving on to the continuing education audit update, the continuing education unit is progressing through the fiscal year 15-16 CE audit process. And then to date, 16 months of the CE audit letters have been processed through November 30th, 2016 as the final month completed for the fiscal year 2015-16 audit. Board staff have randomly selected 10% of the renewing populations of licensees each month. In the interest of managing workload, board staff are scheduling 2 months' worth of auditees for every month moving forward until the backlog is addressed. And then once current, the CE audit process will be conducted on a monthly basis. And I can't tell you what a monumental task this is. We have many audits, and moving through a passing audit is quick, but once there's a problem, it creates a lot of workload, although and the board has been behind on this, but from what we've been seeing, it's very valuable work. It's very valuable to have licensees, be in compliance with their licensing requirement. It's very important for the board to be able to attest to that. And then there's just all this information that's coming out from our audit. So, and I do have to acknowledge my licensing staff, both Vaughn Martini and other people who have helped in the office that have actually worked on their days off, come in on Saturdays, and really championed this program and organized it. So we actually have a good process moving forward. We're making headway and moving forward with the audit, and that feels good for the board that we're actually meeting this requirement. So, and then for regular continuing education audit in the fiscal year quarter 1 and 2, 18-19, the board processed 1,595 CE course applications. And currently there are 588 continuing education providers with a current and valid approval status. So if you need continuing education, I think you can find it in California. Tutorial program update. There are currently 45 active tutorials in progress with the board that have approved tutorial programs. So, and then for quarter 1, quarter 2, fiscal year 18-19, 5 tutorial programs were completed. And then 5 new tutorial programs were approved, and 2 programs were terminated during that period, and both were done at the request of the tutorial student or supervisor, which they both have to attest to quit the tutorial. And that concludes my report. Any questions from the board?
So I have a question.
Yes.
So on that school's Whitewater Institute,
Yes.
so is the school currently treating patients, the students?
We don't do a site visit, so that is one of the concerns. According to them, they're not. They're just beginning their operation, so that wasn't their plan to do that. Again, it would be nice if we could be more boots on the ground as these things develop, because it takes so long to develop a school, so they can operate, again, we don't know what's going on a lot of the times in that period. And for us, they send us the application. In 30 days, we're required to review the curriculum and give it back, and then at that point, nobody's tracking it, right? So, previously, the board would before the board was the sole approver. So we had to take care of all that, including the site visits and whatever. The new process is improved. I think it's a good piece. We can just do a process improvement by it just makes sense for the board at some point to be able to tie this together for the licensees, for the protection of the public, so, to close that loop. And, but we do know the process is working. I mean, we definitely feel supported by having the ACOM relationship. And also, it's also helped the board work very closely with the Bureau of Private Post-Secondary Education, which is really helpful for both of us.
And if I may add, if they do have BPPE approval, then site visits are part of Bureau of Private Post-Secondary's process, so.
Okay.
And also additionally, ACOM creates, they do introductory site visits, then they'll do a staging, and then they do a final very comprehensive site visit that both Ben and I have been a part of to be able to see. So, that's another piece. Where will we set that, where the approval is? To me, you bring up that point, the idea of when they're clinically able to practice seems like that's the point where we, if that's established, we can kind of step back a little bit. Until then, we'd like to know that, so. Because it actually does the practice of acupuncture where some harm could take place.
So the process for the curriculum review for, let's say, an out-of-state program, do they contact us and say, we want to be able to train students that will then practice in California, and we want you to review our curriculum? Or are we, okay. So there's acupuncture training programs in other states that we're not doing curriculum reviews for?
Yes.
Okay.
Yeah.
And is there something in our own guidelines or regulations or in the statutes that say we must do a curriculum review before a student from those schools can sit for the licensing exam?
Yes.
Okay.
Right. That's the BPC 427.5, A, B, and C require those pieces. So one of them is curriculum approval by the board. The other one is approval to operate by, here it's Bureau of Private Post-Secondary Education, but it would be the equivalent in another state, their state education oversight area. And those agencies actually do more institutional accreditations. They take up student concerns, problems with that, where our main focus is public protection. Right?
Right.
And then the third piece that they have to do is have ACOM accreditation.
Accreditation, yeah.
And right now, I'm going to just do a general number because I don't have it in front of me, but it's about 55 programs that can qualify acupuncturists with ACOM across the country, and we have 35 approved programs, right? So a lot of those programs, they already have ACOM in their state. They're operating. They're already, done many years of students. And we found that actually the out-of-state programs, it's sort of the best programs in those states. They're willing to step up their game or to do another piece or to take on another government body or something along that line, right? So that the only thing that they're missing is the curriculum approval. Right. So they use that application for board approval of curriculum, sent that in with all their syllabus and all their course content, and then our staff will work through that. And the way that process works, it's like they apply. If there's some non-compliance, then the application will be denied with exact reasons why. So then, they know what they need to do to fix it the next time. And again, there's a serial denial, the resubmission, which in the old process would be this long, drawn-out corrective action process. Now it's like 30 days back, and then until they get through.
No, it's helpful. That was going to be my next question was the process. And this is more of this is not necessarily a consumer-focused question. It's more on folks entering these programs. Are they told by these programs to the extent that these folks are looking to practice in California, do they have full knowledge going into some of these schools that aren't approved for their curriculum that even though you're getting trained here, you will not be able to sit for the California licensing exam? Or is that dropped on them, after they're done and they've paid for everything? And I'm wondering just, how much transparency is there in which of these curriculums is approved, which is not in these various different schools?
Well, we have, on our website, we'll list the ones that are currently qualified to send students to the CALE. But in California, there's no clinical program that can operate without our approval, right? It's one of the requirements in California. So out of states, they have a separate process. So we have a slightly different role. So all they're able to do is qualify for the licensing exam. And then they're meeting our curriculum piece, which has not only content differences, but hourly differences with out of state. But as part of those people for out of state, whether they know or not, if they ask to take the exam, they'll definitely know at that point, right? And it's this is an area where there's a lot of misunderstanding with it, and particularly with the NCCOM and ACOM having so many different standards in different states about how many hours there are, and then California being way up there in hours. it becomes a real complex issue. So it is out there. I mean, it's like California has whatever the rap on the street, but it's like a bigger hump to get over, whether it's ridiculous or whether it's good or whatever. But the word's out in the street for sure. And in those programs that we saw in the out-of-state programs, they would have their regular program, but they would have to sequester their California students and supervise and make sure they were getting things that other people weren't doing. And for some of those things, there was something that was completely not existent in their program. Like currently, right now, the accreditor, ACOM, doesn't require any science.
Jay, could you pull the mic closer?
Closer to the microphone.
Okay, sorry about that. Usually people say I talk too loud. So I need to repeat any of that?
No, that's helpful. It's helpful.
Yeah.
I mean, I think that the issue, you hit on it. I think
Right.
there's probably issues where students aren't really aware of that because
Right.
they just didn't know proactively, and then they
Right.
get to that situation. That's not necessarily our concern, but.
Right, and the thing is, there's been talk about a bunch of, like this idea of what national standard is, and if we really could truly get there, it would really simplify things for everybody. If we had this, just one set kind of idea what the standard was, like the AMA does with medicine, that would make this process easier, but it's still, we're moving in that direction, definitely. And there's definitely more, abilities on the schools in terms of, certain programs are just shining and developing and growing, right? So.
Yep.
Let's move ahead.
Any questions for Jay on the education report? Seeing none, call for public comment. Jay, if you don't mind just staying there for now.
Neil Miller for Cal Atma. A number of out-of-state, we see more out-of-state CE courses that are offered that say approved for CAP, by CAP. And then people take a course and then they find out that the course isn't approved. In one particular course, that they were selling product and the board felt that it didn't meet the requirements because they were selling a particular product that was associated with them. So we would like to see some sort of, maybe on the website or something where a consumer knows, someone who wants to take a CE course that is actually approved by the board as opposed to someone just saying that they're approved, because we have no recourse to go after somebody who's advertising that it's CAB approved and it's not. And so you spend $1,000 and you find out that you flew to New York and it was for nothing. I mean, you may have gotten the education, but you didn't get the CE units that you need. And this is becoming more and more of a problem as more and more people are looking at cash cow of providing CEs. So we would like to work with the board and maybe put this on for a future agenda item. The other issue has to do with the doctoral programs. There is no board oversight over doctoral programs, and more universities are certifying students to be in their doctoral program. Previous boards had an education task force and had a curriculum competency task force that said that it should be about 4,000 hours is the right thing. Through political maneuvers, we're at 3,000 hours. But it still stands that this body, through investigation of a couple of years, stated that the doctoral level, a number of hours, it was hours for education, then it was a curriculum competency level that was around 4,000 hours. So we would like to ask the board to put on this future agenda item to discuss this, because there's no difference between one school and another school and all these different variations of the doctoral program. Now we want to encourage educational freedom from one institution to the next, but from the consumer's perspective, we want to know that because you're a doctor, that there's some sort of standard. Now there may not be a national standard, but we believe that in California we must have a standard, and we're going to push forward in the next couple of years statutory changes that require an increase in education. It's clear that that's the direction it's going. The different schools are offering these doctoral programs, and our association believes that entry level and a doctorate is the standard that is best needed at this time to satisfy the consumer. Just an example, when our hours were put into place, there was no such thing as an MRI and CT and ultrasounds. So the technology is increasing, and the amount of information that practitioners need to have, both in their own practice and in communicating and working with other specialties, has increased. And we want to take the politics out of this issue. We want to have the board have an honest discussion and perhaps even invite someone from the Business and Professions Committee to come and hear testimony and discussions regarding having the state weigh in, and so that there is a standard across the board as opposed to different schools just giving out certificates without any oversight from a government body. Thank you.
Thank you.
Can I just make one note? I mean, to the extent that there are continuing education programs fraudulently, advertising something, I mean, the recourse would be, a lawsuit to sue them for the money back. So that is something that, I mean, I'm not sure the board can really police that ourselves, but if to the extent students are paying $1,000 because they think it's accredited and it's not, and there's public evidence that there's advertising to that, I mean, that's kind of we may have some rule on that, but.
Is out of compliance, that would, what you described, we definitely have rules on that.
Yeah, so.
But it would be advantageous to the consumer if there was something on the website. So if you're
Can you
approved,
speak into the mic?
I'm sorry. It would be advantageous to the consumer that if there was something on your website that listed it. So if you want to take a class, you could simply go to the acupuncture website, look down at the thing and see that it is approved or it is not approved.
Mm-hmm.
And you would eliminate people saying it's pending approval or this or that or the other, that it's either approved or it's not. And that we would avoid going to lawsuits. That's the whole idea, is that we communicate and be able to streamline the process.
Philip Young from Nanstar University, and also on behalf of the American Association for Acupuncture and Chinese Medicine. We really have the concern about continuing education. I heard at least two of the providers. There's individual provider for continuing education, and their price is $5 per day. Not only the price, their quality definitely is not a kind of quality. Whoever can give some speech, then you get the hours, you get the credit for continuing education. This is really against the principle for continuing education. They cannot guarantee the quality of the continuing education. There's no any improvement for their practice or knowledge. So we hope our board education committee can build up some standard or criteria whoever is qualified to be a provider. And also, do we have the fee schedules or something? So hope that in the future we have more specific standard. Thank you.
Thank you.
Jacques Marco, Empress College. First, I want to acknowledge the tremendous work on the continuing education process and to have so many classes and courses approved. So thank you for that, Jay and Ben. I was audited. I'm very happy to be audited because instead of having 50 units, I have 70 units. And I send in the audits. What I really loved on this audit, that's the first time I saw, they had a specific section, the distance education. And now my question is, possibly we put it on the next agenda item, is, are these individuals getting audited aware of this distance education, that 50% rule that we've been talking about for quite a long time, that this is seat time versus online live, and how are you going to be able to determine that with all the amount of work on all these units? So you're going to have these individuals going to say, well, it's live, but it was distance, so it's going to be a very difficult task to determine that, and maybe as of now into the future, the licensees need to be aware what is the enforcement for those compliances for the CE. So thank you for your work, and I think there's going to be a lot of work ahead. Thank you.
Good afternoon, from morning to afternoon, hard work. And I'm from Los Angeles. We arrived this morning, 4 o'clock. So this meeting is so important because I reviewed the material, 328 pages, and I can see how much work you did for preparation. I do appreciate. And I represent Los Angeles Association called California Acupuncture United Association, and I'm also CalAtma, the United Association's Education Committee Chair. So Mr. Neil Miller already represented CalAtma speaker, so I just represent Kawa from Los Angeles to express some concerns, 2 points. Number one is about the distance, CE class distance. So I want to clarify with board what is the distance. Our understanding is distance is all the online is distance because it's distance. So all non-distance, 25 hour, at least 25 hour. Our understanding is on-site, hands-on, physically you be there face-to-face to the provider. And because acupuncture is a hands-on profession, acupuncture, you cannot do distance. So the study, the learning should have some CE courses face-to-face. So that's our concern. Number two, about the contents of the education, like Mr. Yang said, we have some way to, if we have some way to review that, and if board and you're very busy, if you need something like a professional views from our association, from CalAtma or Kawa, not Kawa, the association CalAtma, I think we will have some professionals to be in the education board, and probably we can do some job for you. Thank you.
Thank you.
Any other public comment on the education report? Nope. Okay. Shall we break for lunch? Looks like lunch just arrived for the members. 1 hour?
Yes. Let's do another lunch. And it is a time.
So 1:30?
To 1:30, we resume with the Education Committee meeting.
That'll be after the CE process review.
Okay.
Thank you.
1:30. Thank you.
Thanks, Dan.
I do that last week.
Yeah.
Okay. No, I mean like moving the items.
Oh, yeah.
Let's do that too. It's 1:40 now. Back to order at 1:40. Thank you. Hope you had a nice lunch. So I want to make an announcement. We're going to move the item from tomorrow, I think, let's see, it's item 12 to 15 to today's agenda. So tomorrow from 12 to 15, we're going to move to today. But we will start with we left with item 9 from today. Is a review and discussion of a board's continuing education process. And G. Hurt, please.
Okay, thank you. The board president and executive officer has asked me to do a presentation of the board's continuing education process. So just to share exactly what we're doing, right? So if you look at the screen here, there's a simple flow chart of our process, but it begins with our program authority, and our program authority is granted through the statute, Business Professions Code 4945. And this requires the board to set standards for continuing education. And it also requires licensees to complete 50 hours of continuing education for each renewal cycle of their licensure. And then there are also some general standards, instructor, some advertising, and then that leads to the proclamation of the set of regulations that actually put out our detailed rules of continuing education through 1399-480 through 1399-489. So if you have a reg book, you can look at that and see that. So if we look at our CE process here, you can see the process begins with becoming a continuing education provider. If you're going to call the board and talk about it, we're going to say, what's your provider number, right? And so this is where you have to start with. So providers apply to become a CE provider, and once that's approved, then that allows them to be able to submit continuing education courses. They can submit by email or fax or by mail. People are tending to move towards submitting by email because the minute they submit them, it timestamps us, and it helps us with our submission guidelines for the practitioner. So when they submit it, they know when they've submitted their application has been received. And so then once we've received the application, the board analyst will review it for its content. We look at things like if the provider status is current, the course content, the instructor qualifications, let's see. And then also there's some other things like advertising, whatever criteria that they look at. And if it passes that criteria, then it gets approved. If it's not, it gets sent back as a denied application. So once it's approved, the process is approved, it gets entered into our recording system, our CE database. That makes the data that we've approved available for easy search. And then also, once a course is approved and it's been into our system, then the providers are notified. They actually get the first page of our application sent back to them by mail, and they retain that as their proof of approval by the board, or written approval by the board. And then also the data that's available for our continuing education database is used to create the web, the listing of our courses on our website, and I'll talk about that a little bit more later. So this is just the picture of our continuing education provider application. And if you're looking at the application, it's a very simple sort of registration type application. It can be used to do new provider applications, provider renewals, which are required every 2 years. And it's also what we use for address change, provider name change, and coordinator change. And the providers and the renewals require a fee, but the address change and the provider name change, coordinator change can just be done by submitting the board that information. And then, so once we receive that information, this is the form that shows from our database that we've captured the information. So it shows the approval date, it shows when the renewal date is, it gives the contact information, and any notes that are going on with the account. So every provider who's approved has this kind of relational ability for us to search them. And so this is the first page of our actual course application for continuing education. And it's basically a series of regulatory compliance attestations by the provider. And they do things like they tell us what their CEP number is, their name. They talk about their contact information, the course title, course date, CEUs, location. They say whether it's live or distance. They specify a category. They provide us with the instructor who the board will verify their credentials. see. They'll list whether it was prior course approval, which is important because if it's a new course, there's a 45-day requirement for submission. If it's a course that's been previously approved and they're just resubmitting the exact same course, there's a 30-day submission requirement. There's attestations around if there's advertising or not. If there is advertising, they have to provide us with the advertisements used, and our analysts will check it for compliance to make sure that the elements that are required to be as part of an advertisement are present. They'll have to disclose if there's any financial relationship with whoever they're working with. And then if they're going to give a test, they talk about the testing criteria. And in the end of it, we get our provider signature and date that basically seals the agreement with the board and the provider. And then the final box is the outcome. So if the course is approved, you'll just get a simple approval, a signature by our analyst, and it gets mailed back to you. And then providers are required to keep this for a number of years in case of an audit. They can actually prove that we've done it. In case somehow we've lost our record, they'll have an original record to work with. And if it's denied, it goes back as denied. And then we'll put some very specific reasons why they were denied, and it'll be tied to a regulation. So, incomplete advertising information, and then a regulatory citation, or, not Category 1 instruction and a regulatory quote, or hands-on and a distance learning, and then we would put the regulatory information for that so that they know how to remedy that problem. And this form can be found on our board's website. If you go to the home page under Education, and there'll be a drop-down menu, and it'll lead to CEs, and it'll open another window, and you'll be able to see these applications on our website. So this is the second page of the application. It's the course objectives, and it's in the course objectives where the provider is going to tell us more information, or the provider and the instructor working together provide us more information, a short narrative of what's going to be included in the class. And this provides the analysts with the information necessary for them to be able to validate whether the course has sufficient content for the hours requested. It'll also allow if it's in compliance with the board's regulation or trigger something along that line. And then it also allows the analyst to at least have some view into whether it's within the scope of practice for licensed acupuncturists in California. So the third page is our outline, and since we're granting CE units by the hour, providers and instructors are required to do a flow chart throughout the day. Typically, we're requiring at least some kind of entry every 2 hours during the day. And even at that, it should be significant information that it would take up that much time. So this is another place where we can find content, or like if something's out of compliance with our regulations, or if it's something like a marketing or selling of a product, or any of those kind of things that we seem to trigger, we'll be able to see it here. And then this is the instructor qualification page. So as we move down, this is just where they show that they're qualified to teach a continuing education course in line with our regulatory requirements, right? So for the first section, it asks for licensed acupuncture status. If it's California, there's a separate box for that, and you put your license number. And if it's out of state, you'll list what state and their license number in that state. And we actually do check those license number, whether they're in-state or out-state, to make they're current and valid and able to go. Out-of-state acupuncturists are allowed to deliver CE units within that CE course, right? So even if they're not licensed here, they can come and they can present a CE course. Now, they can't move right next door and start treating a patient or any kind of a clinical setting. It has to be an educational offering is what's going on with that. And so as we move down the form, there's a place for the instructor to provide their degrees earned, their education. They attest that they have 5 years experience in teaching in this topic, and that they've taught the topic. They've had 2 years in the specialized area that they're teaching, right? So they're attesting to their qualifications. And then for non-acupuncturists, this could be like a medical doctor, or maybe a physiologist, or maybe a Tai Chi martial art instructor who could provide something, and they'll provide their qualification. It could be some kind of certification, some kind of documentation, and the board will accept written evidence of specialized training and evaluate it for if if it allows the person to be competent in that subject area. And then they also have to be able to show that, that they've, evidence that they've had 2 years of instruction in this particular subject area. So this is the look in our backside of our office, how we capture our course approvals in our database. And so you can see all the same information that was on that first sheet has been recorded here. So you can see if it's approved, what category 1, category 2, the number of units, the date, or the location. But the big piece about this is it's readily searchable for us for all these different fields. So when we're doing the CE audit, this is a big tool that we use to validate the audit. And we look at, when we're doing the audits, we look at every course. So it's not, we don't just take what's on there, we'll look at every course for distance live when it's approved. So it's a fair amount of work there. Okay. And then this is our web posting that we do of approved courses. This is, it's on the board's website, again, under the education and continuing education providers. And there's the web address there. And when you pull up that thing, you'll see 4 lists. So we have category 1, live and distance, and we have category 2, live and distance lists available. So the distance lists are pretty static. Once courses are approved, they can be going online. So those provide a really good resources for approved courses. The live courses, now some providers will apply for all their courses at the beginning of the year, and they'll have them up there for people to view on our website all year. You know, the formatting is not the easiest piece, but if you know how to use Control-F search, it's a PDF document, and you can, if you know the name of the course or an instructor you want or a program you want, or you know the provider number, you can quickly use that to search into that field. But we do update this list. Our typical timing on that is about every 60 days, right, for the window of approvals. So if you're a provider, the earlier you get it approved and up on our thing, the more likely you're going to be able to see that.
Jay, can I ask a quick question?
Sure.
Can you just remind us category 1 versus category 2?
Category 1 are practice-related things, laws and government, you know, Western medical skills, laboratory skills, things that are directly applicable to your practice, right, and particularly to clinical practice. Category 2 is things along the line of more personal development, like I'm taking an exercise class for my own ability, like maybe a martial arts class for my own ability that somehow will lead to something else. Or let's say I'm taking a complete marketing class for marketing my practice, you know, or you know, something along that line that's not practice related. That was a great question, John.
Thanks.
Okay. So once a licensee has completed their continuing education, the providers are required within 60 days to send them a completion certificate. And there's requirements of the board has regulatory requirements, what has to exist on this certificate. So they all, you know, things like provider's name and number, course title, participant's name and number, the dates and location of the course, basically verifying exactly the information that was applied for. And then they're instructed to hold this for 4 years. So again, when we do the audit, we request that, that the licensees send in all their certificates from their providers, and then that's what we use to validate their audit. And that's kind of the biggest overview of our process. Does the board have any other questions besides what I've said there? I mean.
So let me see. I have a question regarding, earlier you mentioned the CE provider. If it's from, they don't have a license in California.
Right.
But they can treat patients during the education time.
They can demonstrate. I think if they're treating the patients, they're going to be out of compliance. If there's some kind of fee for service or they're identifying outside what the CE was supposed to be, like let's say we're coming in and we're going to do a thing on their, like, you know, the lung and liver meridian or something like that, and then they end up treating them for a cold or something like that, that would be outside of what it is. But they can demonstrate the exact materials that they're presenting. So it's not a treatment opportunity, it's an educational opportunity is what the point is.
And also they suppose not to, like sometimes, for example, from another country, right? So they come in, they stay here for not just one day, they might be stay for a few days, and they give the lecture one day, and then they go to the clinic to see patients. they can't do hands-on, right?
They can't do that, right. So, and that is a probable thing that does happen that we don't see, right? Because people are allowed to be guest acupuncturists for up to 6 months. So they can come here and maybe do a whole circuit of training or whatever. And then the intention of that was to be able to bring in instructors to help sort of the education of Chinese medicine. But it does need to be delivered just as continuing education only. So the minute they go into a treatment setting, and again, these are often big name practitioners, so there's a real pressure for them to do those kinds of things, right? To show their skills and their competencies, right? So if you feel like something's going on like that, don't hesitate to call the board and let us know, and we'll look into it.
Thank you.
The continuing education category 1 and 2 is I think is categorized based on what you said on the main scope of practice versus others.
Personal development.
Yeah, and does it apply to any? I mean, other medical healing arts board do the same, using the same category?
I'm not familiar with the category. What I've looked at, I haven't seen that, but other boards do have specific areas that they put it. So they do have criteria, right? It's just a form of a criteria about our rule, right?
Yeah, I had a chance to look at one of the continuing education in Korean food practitioner in Korea.
Mm-hmm.
I'm talking about Korea. I have a feeling that the standard and categorization of CEU approval, course of approval, is like whatever it falls into a certain category, then you just approve it. But in Korea, they have definite definition of what their occupational professions, occupational professional definition. Whether it's fall into that, and also they're always changing. Let's say if we are going into more of a primary care, then they put focus more onto that area, so that let's say like half of their mandatory unit has to be in that category. So they are more like directing the subject, and then more detailed clinical qualification.
And those things are possible. You'll see later when we present the regulatory update, the board's talking about making continuing education ethics requirements. So it's sort of along the line of this discussion. And it's just a matter of how it's framed. If you look at our current guidelines the way they are, to do the kinds of things that you're talking about, you still could get those courses approved, but put the competency in, maybe through your professional association, whoever there, and have a higher standard, or even something like maybe find some way to get an accredited program. There are accreditors for CEs that have a different level of requirement, right, in terms of that stuff. But the focus has, I mean, from what I've heard around the DCA, the focus of continuing education for licensing was to keep people current with what's going on with practice, right? So that you go many years, it's a way of keeping it there. It's not really for personal development or for primary education or anything like that. It's for maintaining sort of the standard of care that, like as John was talking about earlier, right? So, as opposed to maybe developing a certificate program so acupuncturists could have more patients or something along that line, right? So,
I thought this was really helpful because a lot of the comments we've heard, over the past year from the public has been around the CE process and the providers. And I guess my question is, to the extent that we find CE providers that let's say are advertising outside of the scope of what we've approved, right? And we heard about certain CE providers saying that they're approved and they're not. What is the process that we take as a board to effectively try to make them stop doing that? And I know it's probably a resource question, right? Do we have the staff to even be doing that type of monitoring? But let's say it's proactively put, to our attention.
Yeah, so again, if we get a complaint along that line, hey, this guy's advertising all the time, we will look into it. And if it's found to be true, right, it becomes an enforcement case. We have authority to You know, they're in a relationship where we can cite and fine them for problems, right? So if we identify a violation like that with a CE provider, our enforcement unit will work up the case and cite them. They'll give them a citation. Now, the person can, they can appeal that, right? And they, you know, so there's, Ben can talk to more of the sort of the process of what happens after that point. But in my mind, it's like they can appeal it and request a hearing, or they can have an informal hearing, and then they can plead to the executive officer, and then, but at that point, his decision's final. So.
And I assume we don't have staff. I mean, we just don't have the bandwidth to have staff members actively, you know, I guess monitoring.
Well, we don't fish. We don't go out and like beat the bushes for it, but any complaint that we hear, we investigate. Every complaint we hear, we investigate. So, you know, we depend on what we're hearing from the outside, but, you know, we can definitely see that we have the authority to view any courses that we're seeing. We have the ability to go to live sites, and so that's where our staff is challenged, right?
We're actually performing audits, you know, just random.
Well, we do perform random audit, right? So that's what I was talking about earlier with the CE audit. The board has typically had trouble doing that, and right now we have started the process, and so we started back with 2015, which was in a 4-year cycle we can do, and so we've moved through the first year of it, and we're doing 2 months a year, and you know, at the point, that'll lead to the point where we're up to date, and then we'll be doing an audit every month. But again, as we talked about the business modernization, we're hoping our new system will have a more robust auto audit kind of ability, right? And then, so that would allow our analysts more time to do some investigations, course reviews, you know, watching live courses. And I mean, we've started a little bit of that, and what we see is a lot of non-compliance. So I guess that kind of validates what you're saying. If we had more staff, we'd find more. And it's just a simple inquiry. If it looks like hands-on, we look at it and it's like, oh my gosh, that was a lot of hands-on for a distance course. So anyway.
And if I may jump in here, I felt there might be a distinction necessary because there's the audits of our licensees and then there's the audits of CE providers. The audits of our licensees is part of our enforcement initiative. Now, the providers as well, however, that's where we get to the staffing issues. In terms of your question regarding being able to take action against a provider offering courses stating we've approved them, it depends. If they're actually California approved by our board, then we have authority. If they're not an approved provider, then we'd have to look at a different route to take them, perhaps the civil route or the criminal route. Now, we could look at discussing this further with the legislature for additional authority, but it would need to be discussed.
So if this is helpful, for the CE provider, you can access the information they approved by, you know, of a board?
Thank you. Yeah, so the best way to avoid that as a licensee in California is to check the board's list of approved courses. That is going to be your document. And then again, if it's not listed there and it's happening soon, it might be between our posting times, because there are some providers that provide their applications at that 45-day deadline or at that 30-day deadline. So it's going to be missing the posting. So you might want to call in. Now, as Jay mentioned, with our business modernization plan, we are looking at systems that will have instant posting. Right, the minute it's approved, it would be posted to a list, and it's a dynamic list. But that will take some time to hunt for that appropriate software and vendor. Any other questions from the board? Also, I wanted to point out one other thing in terms of Francisco's question. For Category 1 and Category 2, my understanding is that's more, that nomenclature is more specific to the Acupuncture Board. And then California Code of Regulations, 1399.483, establishes the categories and has sub-lists of what fits in each of those categories. So if CE providers are confused or if licensees are confused, it's right there for everyone to see. And this is what we are using to approve or deny a course content.
We like to stay within our authority.
That's right.
Thank you.
Okay.
Any public comment?
Jacques Marco, Empress College. Again, thank you for taking some of those consideration with this live and online. Thank you, Jay. Thank you, Ben. I just wanted to just give you feedback. A few weeks ago, I did one of those courses through online with my associate dean, Dr. Ruth. He's the one that always does fill out the different parameter. And I thought it was very well friendly, and it could be done quite at ease. So once you know how to do it, you can do all those parameters. And it was very well put together. So good job on that, and hopefully that's going to make things speed up faster. So thank you again.
Thank you. Any other comment from public? No? So we will move. For someone late, I made the announcement early. We will move the Friday's item 12 to 15 to now. And then we have the Education Committee meetings and also the item 10 at the end. So, Ben, would you take over?
Sure.
And brothers, okay.
So our next item is AB 2138, and Christine, the whole office has really been working on this. This bill was passed last year and goes into effect on July 1st, 2020. And in the packet, we start with the actual language of the bill. This is item 10. And there was a number of items that we needed to clear up. This was what was mentioned earlier by our DCA executive representative. And this isn't for leniency of current licensees, as was noted earlier. This is for how we handle new applications. And the short of it is that the board, unless there's a substantial relationship to the criminal act, cannot consider criminal acts that happened more than 7 years ago as a basis for denying a license. So there's some other more fine-tuned language as well in terms of describing what it means to be rehabilitated if you have been convicted of a criminal act, and then for further definitions on rehabilitations for denial, criteria for denials. So we'll be presenting items 12, 13, and 14 for AB 2138. And actually, we'll be asking Salwa, our legal counsel, to take us through that. So we'll take up the first one, which is item 12, and it will be AB 2138, implementation of substantial relationship criteria.
Yeah, thank you. So just to provide the board with an update, executive officers and enforcement staff has been working with the DCA legal office to develop language that will satisfy the new requirements of AB 2138. So turning to your materials, Christine has drafted a wonderful memo kind of describing the AB 2138 requirements and presenting text that will satisfy these different requirements. So the first one we'll look at is the implementation of substantial relationship criteria. So prior to AB 2138, Business and Professions Code, I believe it was 481, indicates that, boards shall develop substantial relationship criteria. The Acupuncture Board did not actually have a regulation on substantial relationship criteria. So this new text that's being shown will be completely new. There isn't, an amendment to the board's current regulations. And what AB 2138 does is it actually defines specific criteria. If you turn to the second page of the memo, it identifies that substantial relationship criteria shall include, and then it says, it has the bullet points 1, 2, and 3. So turning to the text, the board staff are presenting two options that have been worked on with the legal office.
Sorry, just to point out, the text is after the next green sheet. So we're introducing the memo, and then right after the green sheet is the text.
Yeah, so I'm not going to rehash everything in the memo, but I will kind of just point out the differences between the two options being presented. So in option one, we have the introductory language that introduces the substantially related element that boards will look at in evaluating professional misconduct or crimes, or those violations pursuant to 141. 141 is basically violations committed outside of California or in another jurisdiction. But if you go to subsection B, there you have the substantial relationship criteria, 1, 2, and 3, that's being required by AB 2138. This text is modeled after what other boards have already adopted as substantial relationship criteria. So what the legal office did is they took the two most common substantial relationship criterias that have been adopted by other boards, and they kind of tweaked it and amended it to satisfy AB 2138. So option one is the more simple form that straightforwardly responds to AB 2138 by including those three criteria there. Option number two is a bit longer, mostly because of subsection C, and it gives examples of crimes or professional misconduct or acts that might be substantially related, and it has 1 through 8. This is not language that's necessarily been offered by the legal office in response to AB 2138. This is just some pre-existing language that some other boards have already incorporated in having substantial relationship criteria. So really, it's that subsection A and B that is responsive to AB 2138. So my understanding is that staff would recommend option one, and some of the rationale for that is that it's simpler and cleaner. And also in our focus groups where these have been discussed, some felt that option C actually takes away from the clarity insofar as that when, let's say, licensees or ALJs or applicants are looking at this subdivision C, they might think that the board has to kind of go through this list, or that this is some kind of checklist, or that it's all-inclusive. So, some have felt in looking at the two options that it's better to just not have the list. Examples aren't really needed, and really all you need for AB 2138 is that B 1 through 3 there. So other things to point out is that with regards to option 1 and 2 is this was modeled on what other boards have had for their substantial relationship criteria, and specific additions have been adding a reference to 141, because under 141, boards are authorized to consider those crimes committed in outside jurisdictions that are substantially related. So in that way, it's relevant here. And also the addition of professional misconduct there in subdivision 1, so that the boards can deny, suspend, or revoke for 141 items, but also for crimes and professional misconduct. And professional misconduct, I just wanted to point out, is new pursuant to AB 2138. Allows the board to deny, suspend, or revoke for professional misconduct that is substantially related. So that's new in response to AB 2138. Yeah, and that's just basically what I wanted to point out about these two options. So if you have any questions.
So if I may clarify, then is it accurate to say that option 1 gives the board more discretion and option 2 gives the board less discretion because of the more confusing nature of the language to put in the checklist?
Option 2 does use that language that says it shall include, so for purposes of subdivision A, substantially related crimes, professional misconduct, or acts shall include but are not limited to the following. So I don't know if I'd go so far as to say that one gives more discretion over the other, but I think that that's how it can be interpreted by some, and to that extent, I mean, what we've heard is that might be confusing and take away from the clarity of the regulation, and so some have preferred the simpler format of option number 1.
Thank you.
I will say that when, rulemaking packages are submitted to the Office of Administrative Law, what they're looking for are necessity, clarity, consistency. So some of the things to consider is whether or not that extra subdivision C is necessary, kind of that conversation about whether or not some might find it confusing would go to the element of clarity. And then also something to take into account is consistency. Now, neither of these, I think, of these options would be internally inconsistent for the Acupuncture Board, but we are encouraging the different programs to kind of adopt uniformity with each other. So the different programs, to the extent that they can, have kind of uniform regulations on this.
Thank you. Any questions, comments from the board members?
Well, the option number 1 does simple and clear. It's easy to understand.
Yeah, I prefer option number 1 too, for the reason that I do think that there's a risk that, in applying this, future boards will think, as our council mentioned, that this is an exhaustive list, right? And it might be confusing in that way. So I like option number 1. It seems cleaner.
Yep.
And just to reiterate, we're on a timetable for AB 2138. I'm not trying to back anyone into a corner, but we do have to make a decision on one or the other option at some point, and we are trying to meet the 2020 deadline.
I think the timeline that was put in place was by May, so to have something on file or.
Noticed for a while.
Yeah.
Yeah, I mean, I would motion for option number 1 unless, anyone have any other questions? I can wait, but, okay. So I'll make the motion for option number 1 for approve the proposed regulatory text of option number 1 of Title 16 CCR Section 1399.469.4, direct staff to submit the text to the Director of Consumer Affairs and the Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
I second.
We have a motion on the table. John Harabedian, seconded by Amy Matecki. Can we have a roll call vote, please?
Public comment first.
Oh, thank you. Public comment. Seeing none, we'll go to roll call.
Okay, Dr. Matecki?
Yes.
Chan, absent. Chimino?
Yes.
Harabedian?
Yes.
Kim?
Yes.
Lee?
Yes.
And Osorio is absent. So the motion has passed 5-0 with 2 absent.
Thank you. The board has chosen option number 1. We can move to item 13.
Okay.
This-
Oh, sorry, go ahead.
Nope. This is just moving on with AB 2138. This is the implementation of rehabilitation criteria for denials. And we'll hand it back to council. Thank you.
So substantial relationship criteria applied to denials, suspensions, and revocations. Here we have rehabilitation criteria for denials, and then a separate regulation for rehabilitation criteria for suspensions and revocations. And that is also kind of modeled on the way, some boards have been doing it. I think this would be looking at it, all new regulations for this board. It's Business and Professions Code 482, I want to say, that requires the board to develop rehabilitation criteria. And some of the changes from AB 2138 is that it says that the board shall consider two things for rehabilitation. One, whether or not they've completed a criminal sentence successfully, and two, any other rehabilitative information. And the AB 2138 doesn't identify particular rehabilitation criteria other than those two things that I just mentioned. So anyway, going back to rehabilitation criteria for denials, I won't rehash everything that's in the memo, but I will kind of point out the differences between, some main differences between option 1 and option 2. Option 1 kind of gives the board more discretion in whether, so I'll say, option 1 says that the board shall consider whether or not the applicant has successfully completed their criminal sentence. They shall consider it. Now, if the board finds that they've successfully completed their criminal sentence, but that isn't sufficient to show rehabilitation, the board can go on to subdivision B and look at specific other rehabilitation criteria. Option number 2 is gives the board less discretion in that it says that if an applicant has successfully completed their criminal sentence, the board shall find that the board shall find that the applicant has made a showing of rehabilitation. And subdivision B would only apply if subdivision A does not apply. So if the applicant has not successfully completed their criminal sentence, then you would move on to option B. So please feel free to let me know if that didn't make sense. I can explain it some more. But essentially, we've provided these two options to the board. First one being giving the board a little more discretion, the second one being a little more restrictive. And the only other thing I will point out is there is some case law out there that says that simply satisfying criminal sentence or the requirements of a criminal sentence doesn't necessarily constitute rehabilitation, which sways towards option 1, and I believe staff's recommendation is option 1 for that reason. And with that, let me know if you have any questions.
Thank you. I would like to give the board more discretions, just.
Yeah, and I'll just echo the sentiment that just because one has finished a term of probation or parole without a violation just doesn't necessarily show rehabilitation. So I completely agree with that. And I think option number 1 gives the board just a lot more flexibility to consider the facts before it and whether we've made that determination of rehabilitation, rather than in option 2, it seems to potentially limit our discretion. So I think option number 1 would be what I would prefer.
Yep.
Any comments from other board members?
So I'll make a motion for option number 1. I'd move to approve the proposed regulatory text of option number 1 of Title 16 CCR Section 1399.469.5. Direct staff to submit the text to the Director of Consumer Affairs and Business Consumer Services and Housing Agency for review. And if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package and set the matter for hearing.
So motioned. Do we have a second on the table?
I will second.
President Matecki seconds. Public comment? Seeing none, let's move to roll call vote.
Dr. Matecki?
Yes.
Chan is absent. Chimino?
Yes.
Harabedian?
Yes.
Kim?
Yes.
Lee?
Yes.
And Osorio is also absent. So the motion passes 5-0, and approval of option 1 for regulation section 1399.469.5.
Thank you.
Thank you.
We'll move on to item number 14. This is the last of the three related to AB 2138. This is the implementation of rehabilitation criteria for suspensions or revocations. And again, I'll pass it to council.
Again, we have another great memo done by Christine that kind of lays out some of the background and describes the two options and sets out the motions that the board can put forward. This is AB 2138 on the implementation of rehabilitation criteria for suspensions and revocations. It's very similar to the last one, except this involves the disciplinary process of licensees rather than applicants, which the last one was denial for applicants. Again, I'll just point out the main difference between the two options being that option 1 allows the board to consider whether or not there's rehabilitation based on successful completion of a criminal sentence. And if the board doesn't think so, can move on to Part B. Sorry.
Take your time.
And the second one is more prescriptive in that the board shall find rehabilitation. And can only move on to Part B if Part A is not applicable. So with that, let me know if you have questions.
Got it out.
Got it out, yeah.
And I think consistent with the last conversation that we just had, I would prefer option number 1 for the same reasons, which again gives us more flexibility
Yeah,
for all the same reasons. So,
I agree with John.
Well, what I'll point out also, unfortunately for me, because I've talked some more, is that the subsections A 1 through 5 there, and then B 1 through 5 are not, those aren't criteria that are specifically set out in AB 2138. But I believe it was based on kind of like looking at the various boards' guidelines already and what regulations they already have in place and what they're considering. That's what that's based on. So if the board wants to look at those sub-criteria as well, it can. They're not fixed by AB 2138, but what we do encourage is kind of uniformity. It'll also ease the packages route through OAL's desk, because they are going to be looking at a lot of these packages for the boards. But at the same time, it would be important for the board members to look at them and consider them and make sure that that is what you want. And that applies to this one and the last one.
Thank you, council.
Thank you.
Sorry, made it.
Yeah, with that in mind, I'm comfortable with the criteria, but, okay.
You might just move it.
Yeah, I'll make the motion to approve the proposed regulatory text of option number 1 for Title 16 CCR Section 1399.469.6. Direct staff to submit the text to the Director of Consumer Affairs and Business Consumer Services and Housing Agency for review, and if no adverse comments are received, authorize the executive officer to take all steps necessary to initiate the rulemaking process, make any non-substantive changes to the package, and set the matter for hearing.
Member Harabedian, motion. Do we have a second on the table?
I second. Okay.
Have a second? Public comment? Seeing none, we'll move to the roll call vote.
Dr. Maiteki?
Yes.
Chan absent. Chimino?
Yes.
Parabedian?
Yes.
Kim?
Yes.
Lee?
Yes.
Osorio absent. So the motion passes 5-0. And the motion is to approve option 1 for regulation section 1399.469.6.
Excellent. Thank you, board members. That was some good work there. Staff has been busy on that for some time now.
Water break?
Water break?
Water
Yeah, let's take a
break.
little. Shall we say 10, 15 minutes? 15?
Yeah, 15 minutes. Let's do 15 minutes.
2:45? Back at 2:45?
2:45. Back to 2:45.
Thank you, audience.